Ruth, Your Honor?
Yes, sir.
Ma'am, could you please tell us your full name and spell your last name?
Rebecca Ruiz, R-U-I-Z.
I think you can take your mask down to make sure
Yeah, you
that
can take
everybody
it down.
can hear you. And where are you currently employed, Ms. Ruiz?
State of Florida.
And how long have you been employed with the state of Florida?
17 years.
What do you do currently with the state of Florida?
I'm an official court reporter.
And were you working in your capacity as an official court reporter yesterday afternoon, Wednesday, October 27th of 2021?
Yes.
And specifically, were you reporting the goings-on of the trial of State of Florida versus Markeith Loyd?
Yes.
Did there come a point where you observed Detective Shane Overfield of the Orlando Police Department on the witness stand?
Yes.
And was there a time when you heard him make a statement referencing a Deputy Norm Lewis?
Well, he never used that name. The statement that he made was, did I say his name? I don't think I know his name, or I don't think I even knew his name, something to that effect.
All right, now, where were you sitting in relation to Detective Overfield when you heard this?
Right in front of the jury box, witness box.
So maybe 5 feet from him?
Less.
Less than 5 feet. And you just repeated verbatim what you heard?
Correct.
At the time the statement was made, was the jury in the courtroom?
No.
No further questions, Your Honor.
Cross, Mr. Linneman.
Yes, thanks.
Good morning.
Good morning.
Now, you were the court reporter transcribing this event during trial, correct?
Correct. Well, one of them.
And there were actually two portions that you were involved in. You were involved in a portion when Detective Overfield was testifying before the jury.
Correct.
And then you were involved in overhearing some things after the jury went out.
Correct.
Okay. I want to talk about what happened while the jury was here.
Okay, wait. I need the record to stay straight. Right now, all we're addressing is whether or not the comment by Overfield was made while the jury was present. Do you have any questions about that?
Not while the jury was not present.
Okay, so, and you've conceded that basis for a motion for mistrial, you're withdrawing that one.
Right, but my concern...
Hold on, I know what your concern is.
Okay.
My concern is the record, all right?
Yes, on that basis.
So, that motion for mistrial, on the basis that that the jury might have overheard the officer say anything about using Norm's name, Detective Overfield, is denied. There is no evidence that the jury was in the room at the time. You want to ask her questions about what? The mistrial I already denied about Overfield saying the two officers who died on the stand?
Yes, I do, because I don't want there to be confusion on the record that there are two different incidents.
I don't think the record's confused about that, Mr. Williams.
Yeah, we would object to eliciting any testimony about that because it was recorded by the court reporter.
There is an official transcript of that. It's in the transcript. I have a copy of it.
Okay.
So asking her questions about it is
That's fine.
not
Then I want to
necessary.
address, though, that particular statement.
So we're done with Ms. Reeves. She can
Yes.
step off. Thank you.
Okay.
All right. You've already made a motion for mistrial on this, and I've denied it. So
Correct, but I did not point out
Do you want to, let me finish, Mr. Lenneman. Do you want to add to your record?
Yes.
Go ahead.
Okay. So, Judge, it doesn't appear, it's in the transcript, that Mr. Williams acknowledged that there were two officers that were deceased in his response to the detective. He asked this question: did you eventually obtain some guidance on what to do with your projectile? And the answer was yes. He asked me to attempt to make contact with the CSI, and I called CSI Karen Livengood. Livengood, I apologize, and she was busy. There were multiple incidents that stemmed from this. that there was 2 officers that were deceased. That's what it says in the transcript. And Mr. Williams' response is, yes, sir, I'm familiar. So after we filed a motion in limine, and then it was stipulated by both parties that we would not ever bring this up, the prosecutor himself acknowledges about the 2 officers. And that's what I wanted to add to the record, Judge.
State.
I don't need to tell the court that that is not the entirety of my response. And I think it was addressed at the bench when the motion was initially made, that my statement, I'm familiar, was stepping over the detective to make sure that he did not go any further with the statement about the second officer. By the way, which the record doesn't say second officer, or doesn't mention Norm Lewis, and all it says is deceased. So there's nothing in the record that even directly references the deputy or the court's order. But I did, in my view, immediately step over the testimony of the detective to ensure that the court's order was abided by. And as I mentioned at sidebar when we argued this initially, the answer was non-responsive. So I vehemently deny the suggestion that I in any way attempted to bring out the information or did anything but everything I could to ensure that it did not come out.
All right, the court ruled on this yesterday, but I'm going to reiterate what I'm saying. I did review the transcript in detail, all of it, including up until we went sidebar on the motion that was made by the defense as to what exactly this officer said on the stand. It was very quick. There was no mention made that Mr. Loyd was in any way involved in this. He clearly said there was a second officer who died, but I think it went by so fast. I offered the defense a curative instruction. The defense said no for reasons that are legitimate, which is it would just have drawn attention to it. I just don't believe that the jury, if they caught it, I don't think any harm was done. So motion for mistrial is denied. Now, we need to move on to something else, folks. I was advised by deputies this morning of 2 separate incidents involving the jury. Actually, it's multiple incidents. So I'm going to start with the one that I believe is an easier one to resolve. 3 deputies have been asked by jurors, either here at the courthouse or on the ride to and from the hotel, how much their gun belts weigh. 2 deputies said, I don't know. 1 deputy said 30 pounds. State. I am, by the way, going to talk to the jury again this morning. Go ahead. About conversations.
Right. I think the only thing we have to say at this point is that any law enforcement officers having contact with jurors should not be answering questions about anything that's not directly related to making sure they have what they need. If you're asking, I don't know what else the court is asking about, but that's the statement that I would make at this point.
Defense.
I'm thinking, Judge.
I'm sorry?
I'm thinking.
Okay. You're going to need to put your mic on after you finish thinking. The jurors were previously instructed by the court in their package that they are not to have any conversations with the deputies other than about the weather and sports, and I specifically wrote that out. Go ahead.
Judge, our position is that...
Mr. Lenneman, I can't hear you when you're sitting down.
Our position, Judge, is that you should instruct them just as you said you were going to do.
Okay, I'm going to re-instruct them because they've been instructed once. All right, here's the next issue. I have the juror numbers here. I'm not going to call them out at the moment. It's 2 alternates and 2 folks sitting on the jury. Last night, 4 jurors were in the juror lounge. Deputies overheard the following comments. Judge is getting frustrated, long breaks, sidebars, and everything keeps stopping. Defense is over him, Loyd and his outburst. The deputies immediately intervened. The supervisor was called. The jurors were told you cannot discuss anything about this case until you've reached a verdict form. Judges instructed you on this. The jurors stopped the conversation. One of the 4 jurors that was involved also made a comment to I think the supervisor, I'm not 100% sure which deputy. And the comment was, if they were honest back at the courthouse, half of these people wouldn't be here. We are more strict here at the hotel. I was told about this about 8:30 this morning. Which part? All of it? The last one? If they were honest back at the courthouse, half of these people wouldn't be here. We are more strict here at the hotel. I have no idea what that means. The deputies followed my instructions, which is you are not to say anything other than you cannot talk about this case until the judge sends you in to deliberate. So you need to stop talking. I don't know what any of these comments mean. My intention was to let you all know and then bring the jurors in one at a time if necessary and start having conversations with them. Again, we have 2 alternates and 2 jurors who are part of the 12 that are involved in this. And then the last comment, hold on, I have to check a juror number to tell you if that's an alternate or someone on the panel. It's an alternate who's involved in the last comment. State.
We have no objection, Judge.
All right. Let me start with juror number 2000, please. What? I can't hear a word you're saying.
Judge, I obviously know you probably will ask this, but obviously it appears there may be other conversations taking place between these jurors.
I'm going to find out.
Okay, thank you.
I'm not one for sugarcoating problems. We need to give him a mic, please. Good morning, how are you?
Hi.
Okay. I have some questions for you about some conversations that occurred at the hotel yesterday.
Sure.
It's very important that you tell me the truth about all of this. As I've told you all from the beginning, the only thing we're actually looking for in this case is the truth. And we need to make sure that jurors are following instructions so that any verdict that is rendered is a fair verdict to both sides. So let me start by asking, did you have a conversation yesterday with 3 other jurors in the juror lounge about anything that was going on in this courtroom?
Not the evidence.
We need the,
I'm sorry.
yeah.
Not evidence or not any testimony or anything like that. I think somebody felt, I don't know if I want to say your frustration with like interruptions and things like that. I'm not sure. And I think that's what it had to do with all the meetings and the stoppages and things like that.
Okay. Did anyone talk about or say something to the effect of the defense is over him?
I don't remember,
Remember
those.
that? Do you remember anything, any comments about Mr. Loyd or his attorneys?
No.
Do you remember why anyone thought I was frustrated?
I don't know if it's facial expression. I'm not sure. I was just there.
Okay. Is there anything about what was said that would influence your decision about the verdict in this case, one
No.
way or another? All right.
No.
Then you apparently had a conversation with a deputy in which you made a comment along the lines of, if they were honest back at the courthouse, half of these people wouldn't be here. We're more strict here at the hotel. Did you have a conversation like that?
Not that per se.
Not that specific?
No.
I mean, this is paraphrasing, I think. What was the conversation that you had?
Okay, I think with the lists that everybody's been giving you about every single thing, I felt that I think I was looking at the why behind the what. And I think jurors felt that the instructions for the sequester were not what's happening in the sequester. What I mean by that is the sequester is actually a lot more strict than what they were expecting. And I said to her, I said, I think that's why you're getting these lists of concerns.
So this was about the questions about having a drink at dinner or not having enough games to play, all the administrative questions you all have been asking me.
Yes.
Okay. Had there been any conversations that you have overheard about this case other than what we have discussed this morning?
No.
All right. State, do you have any questions?
No, Your Honor.
Defense?
Good afternoon, sir. How are you?
Good, how are you?
Good. Now, I know that there's been interaction with the deputies that have been reported, but did you have any other interaction with deputies where you asked questions related to the case?
No.
Did you overhear any of those conversations?
No.
Okay. Is there any conflict between you and any other juror?
Not that I know of.
Okay. So what you're saying, that this was all related to the issue of these lists, and that you guys being kept at the hotel during this process is much stricter than people thought it was?
Right, you put 18 individuals together, and what we got was like a 4-page informational about what a sequester is. And again, we're all laymen. We don't know anything about this process. And people are used to being free to say things. I mean, sometimes people just spontaneously say things because they're working out of stress or whatever. No one's trying to do the wrong thing. That's what I think. And I think that's why you might be hearing some ancillary conversations and pieces of conversations that may not be what they appear to be. And that's just my opinion, and I see things. And I saw the stress, I see the stress on the deputies' faces when they see that there's another list and they're getting instructions from the judge. That's got to be stressful for them, because they're just trying to be safe for us. They're trying to keep our safety. And that's where I'm at with it. And that's one of the reasons I said to the sergeant, I said, I know you probably don't like getting those lists of, quote unquote, I don't know if we want to say the word complaints, but I want to use the word concerns. They probably don't like it, and I would guess. They want to do the best by us as well as do what their duty is. So that's all I said.
So what you're saying, I just want to make sure I'm clear, is that you're empathetic to the plight that the deputies have in dealing with jurors?
Yes.
Okay. And therefore, you obviously don't agree with some of the things the other jurors are saying or asking for?
Again, 18 individuals. We are not going to agree on every single thing, but they're an individual. They'll be responsible for what they write down on the list or what we agree to. Some things I agree to, some things I don't.
Okay, and the final question is, were you one of the participants in the conversation where you felt sympathetic or empathetic to the judge's plight and her responsibility?
I don't know if it would be sympathetic or empathetic. It would be, I guess you could say it's empathetic, because I would say understanding, but she's got to keep this going. She's got to keep the trial moving forward. And I think that's what the gist of the conversation was.
And is there sides, like you're on one side and
Objection to this question.
Sustained. You're going to.
I have nothing for
All right. Thank you, sir. You can return to the jury room. All right. Let me speak to Juror 294, please. I forgot. Claire, can you bring out 2000 for me real quickly, please? 2000, bring him back out here, please. Thanks. I forgot, you can stand right there. I forgot to tell you, you are not to discuss anything we discussed in this courtroom with anyone else. All right, thank you. Good morning.
Good morning.
How are you doing?
Pretty good.
Good. As I've told you all along, when I ask you all questions, when any of us ask you questions, the only thing we're looking for is the truth, okay?
Sure.
We have to make sure that things are running the way they're supposed to in these cases. So I have a report that you were involved in a conversation with 3 other jurors last night in the jury lounge concerning things that were happening in the courtroom.
Yep.
Can you tell me what was said, please?
Yeah, there was a comment about yourself being frustrated about the audio
About
usage.
the audio, you said?
Yeah, microphone usage by one specific individual.
Okay. Anything else that you remember about that conversation?
No, that was the conversation as
Or
far
any
as I remember.
Or any comments made about Mr. Loyd and his defense lawyers or his defense lawyers?
Not at all.
Okay. Any other conversations that you've had about anything that's going on in this courtroom?
Not at all.
Okay. Have you overheard any other juror having a conversation about this case?
No, ma'am.
And I'm going to instruct all the jurors, when I told you all you can't talk about the case, I meant literally, you can't talk about anything. You can't talk about whether the lights went off in the courtroom. But I clearly was not that specific, and I'm going to be, all right?
Yeah, no problem. I was just
So-
listening.
I understand. I'm just trying to find out what happened. We need to have a clean record as to what occurred. So, State, do you have any questions?
We don't, Your Honor. Thank you.
Defense, do you have any questions? Okay.
Good afternoon, sir. Good morning.
Good morning.
Were they talking about me?
Yep.
Okay. And what were they saying besides the microphone issue?
That was literally it. I think there was a comment that there was some frustration over the microphone.
And in terms of frustration, was anything said that they were blaming me for not wearing a microphone properly?
No.
Okay. Was there any blame towards the defense at all?
It wasn't a conversation. It was one comment.
By one person?
Yep.
Okay. Judge, I don't know if this is appropriate to find out who that juror was.
I'm going to ask the other
Okay.
jurors.
I have nothing further. Thank
All
you,
right,
sir.
thanks. Thank you, sir. You can't discuss anything we just talked about, all right? Thank you.
Yes.
So I'm going to need 797, please. Good morning, have a seat. How are you this morning?
I'm doing pretty good. So,
Okay, so I have some questions for you, and the attorneys may have some questions.
okay.
We're just trying to find out what happened, so just tell us the truth, okay? Were you involved in a conversation yesterday in the juror lounge after last night's court proceedings that involved anything about anything that may have happened in this courtroom?
Yes.
Can you tell me what that conversation was?
We just briefly said that it seemed like you, I'm trying to say you were maybe
I'm sorry, I can't hear you. Go ahead and take your mask down. It said what?
I really can't describe what was said, but pretty much about the attorney. It seemed like sometimes you can't hear him, and he gets a little upset sometimes, pretty much.
That I get upset?
Not him, I'm sure the attorney.
he gets upset?
Yeah, sometimes
Okay.
because can't hear him. And in turn, you might get a little upset as well. Not upset, but, you know, with the process, pretty much.
Was it one person? Everybody was talking about it?
There were, I think, maybe 4 of us, and one person said one thing, and someone said, just reiterate what it said. So it wasn't every single one. It was like 4 of us watching a basketball game, and we're just sitting around, and we just brought it up. And it was very brief in a way. It was nothing demeaning, just our observation.
Okay.
That's pretty much it.
Was anything else said about the defense at all, Mr. Loyd, his lawyers, anything like that?
No.
Is there anything about the conversation that would influence you one way or another in this case?
Not at all, no.
All right.
No.
Thank you. State, you have any questions?
We didn't think anything of it. If we did, we wouldn't have, even discussed it. We just thought it was just like a general conversation that wouldn't affect anything at all.
Okay. State, you have any questions?
We do not, Your Honor.
Mr. Lenneman, do you have any
Yes, thank you.
questions?
Good morning, sir. How are you?
Good morning, pretty good. How about yourself?
So I assume I was the topic of conversation.
Not really you, but it's like a general conversation. It wasn't specifically addressed to you. It wasn't at all, no.
Okay. So I wasn't the one that you guys were talking about that was either not using his microphone properly or getting frustrated with his microphone or any of those things that I thought I interpreted you saying.
No, you was mentioned, yes, but not really about you specifically. Sometimes, I guess the witness wouldn't hear you, and you might raise your voice somewhat, but not really that.
Okay. So did you interpret that as, was there criticism about the way I was handling that portion of my job?
It wasn't a criticism at all, no. No, it wasn't a criticism at all, no.
Okay. Just an observation.
Correct.
All right.
Correct.
I don't have any further questions. Judge.
Thank you, sir. You can't talk about anything we just talked about, but you
Right.
can go back to the jury
Yeah.
room.
All
Appreciate
right.
it.
You're welcome.
Can you send juror 781 in, please? Have a seat, sir. Good morning. How are you?
I'm doing good.
I'm good. I have some questions for you about last night at the hotel.
Yeah.
As in any time that we ask you questions, we just need you to be honest with us, okay?
Okay.
Were you involved in a conversation in the jurors' lounge after court was over yesterday with 3 other jurors about anything that went on in this courtroom?
I was in the jurors' lounge, and I was in the same group. I wasn't a part of the conversation, but I did hear the conversation.
Okay, what did you hear?
So I heard they were talking about basically like the attorneys. So saying, this attorney is kind of like this, that attorney is kind of like that. Just like talking about, how each attorney is acting, I guess.
Okay. Were they being critical of the lawyers or just commenting?
It was basically just commenting, because
Did they say anything else that you can remember?
no,
Did you comment on any of it?
no,
Is there anything that was talked about or commented on that would influence you one way or another in making a decision in this case?
no,
State, you have any questions?
Yes, Your Honor.
Go ahead.
Was there any conversation about the evidence in the case at all?
no, there was no evidence, discussion of evidence.
That's all, Judge. Thank you.
Mr. Lenneman?
Yes. Good morning, sir.
Good morning.
So what I heard you say was the others were commenting about more than just one attorney.
Yeah.
Okay. And do you remember what the comments were?
It was sort of about like, how like, okay, so for example, how the mic is like okay, this attorney's, their mic is sometimes not on, for example, and stuff like that, and you can't hear them talking and things like that. It's along the lines of like that kind of like the behavior. It's like things you've noticed in that regard.
Okay, and was the attorneys whose mic wasn't on, were they referring to me?
Yes.
Okay. Did they refer to any other attorney in the conversation?
Yes.
Who was that?
This gentleman here.
You're pointing to,
On the left, I don't know my name.
okay, on your left?
On my left, yes.
So this gentleman right here?
Yes.
Okay. He's pointing to Mr. Williams. And what was said about Mr. Williams?
Okay, so yeah, they were saying, basically, he's making a lot of objections. So it's like persistent or something like that. Comments around that nature.
Okay. And were they being critical of him?
Not necessarily. I guess it was just like, I'm not sure how the conversation started, but they just made comments about, this, he's making a lot of objections, and then, like your mic is going off or it's not on and stuff like that. But it wasn't like an opinion on how, like a critical opinion or anything.
Okay. That's all the questions I have. Thank you, sir.
You're welcome.
All right, sir. Have you been part of any other conversations about this case outside of this courtroom?
No.
All right. Thank you very much. Please don't discuss what we've talked about with the other jurors. Just go on back to the jury. I'll be
Okay.
with you all in a minute.
Mm-hmm.
Thanks. State, anything you want to say? I'm going to instruct these jurors again, but state,
No, Your Honor, we do not.
defense? All right, so here's what I'm going to do. I'm going to bring them in, and I'm going to instruct them again. I'm going to be a lot more specific. And I'm going to address the issue of the fact that jurors think I'm getting frustrated. I don't think there's anything else I can do. So nothing of this, I mean, I assume nobody is moving for me to remove any of these jurors. State?
We are not moving, Your Honor.
Defense? We are not. All right. All right. Anything else before I bring the panel in?
Bring the panel in to begin evidence and...
No, bring the panel in for me to chat with them.
Oh, okay. We need a few minutes, 5 minutes maybe, before we start testimony, but as far as before you have a conversation, no, Your Honor.
That's fine. Can you do what, while I'm talking to the jurors, can one of you take care of starting your, or are you going to need a break after I talk to them to get done what you need done?
We're going to need a break. I apologize, but
That's not a problem. They're going to need a break probably too after I chat with them.
Well, Judge, we have a discovery issue. I
right,
believe
well-
it's a discovery violation.
Well, let me talk to the jurors so they can absorb what I'm telling them. I'm going to have to send them out of the room anyway, and then we'll talk about whatever it is you all
Okay.
want to talk about. Let's bring the entire panel in, please. State recognized, presence of the jury.
We do, Your Honor.
Defense?
Yes, ma'am.
All right, good morning, everyone. I wanted to chat with you all a little bit before we start testimony this morning. It's come to my attention that a couple of things are going on that I think are a result of me not giving you correct instruction, or giving you not enough instructions. We sometimes forget that this is something we're used to doing, and jurors are not. This is all new to you. So sometimes I leave out specifics. So I'm going to give them to you now, because I want to make sure that you're properly instructed and understand. So let me go over again what we mean by you can't have any discussions about this case outside of this courtroom. It literally means absolutely nothing. You don't even talk about the lights going off in the courtroom if they should happen to go off. I mean, that's an exaggeration. But anything that's related to the trial, the people in the trial, the clerks, the attorneys, the people in the audience, you can't talk about any of that. You cannot discuss this case or anything about it outside of jury deliberations when you're handed the case to reach a verdict. Does everybody follow me? And I do apologize, folks, but like I said, we sometimes assume more than we should about what you guys know. All right, so that's the first thing I wanted to talk to you about. The second thing is the deputies, don't ask them anything. Remember in your jury packets I said, talk to them about sports and the weather? Talk to them about sports and the weather. You can talk to them about the hotel and how nice it is or it isn't, but don't ask them anything about them, their jobs, even as innocuous as it seems, the patch on their uniform. Don't ask them. It puts them in a really awkward position. I have instructed them as to what conversations they can have with you so that neither the deputy nor you gets into a situation that causes a mistrial or a problem in the case. And so anything outside of the world's most innocuous topics, the World Series is on. How many of you are baseball fans? Talk to them about the World Series. There's not a lot of you that are baseball fans, but the hotel, how nice it is, the weather. You can talk about your family, your kids, your grandkids, your dogs. Just stay off the subject of anything that's not completely neutral and has nothing to do with the legal system, their jobs, or anything else. And then lastly, I want to address an issue with you all. I don't think it's a secret that I find the sound system in this courtroom frustrating. I think everyone finds the sound system in this courtroom frustrating. And I try very hard not to remain completely neutral, not to communicate that to any of you, and have apparently failed miserably, and for that I apologize. You should not read into anything that my frustration with the sound system, that I'm angry or upset with any of the lawyers or anyone, because I'm not. I'm just frustrated that you guys can't hear, I can't hear. I'm constantly having to say to folks, please speak up. I've got a lot going on up here beyond having to listen to this, and I'm afraid I've let that frustration show. And for that, I apologize. I'm a little embarrassed by it because it's not my job. It's my job not to let that frustration show. But please don't assume by anything I say or do that I prefer one side over another or that I'm upset with anybody, because I'm not. I do this all day long, every day, and I'm used to the ins and outs of trials and the having to repeat myself. It's common in trials. In this courtroom, every judge who tries a case in here finds themselves saying at least 10 times a day, I can't hear you, turn your mic on, speak up, please. So ignore my reactions because they don't have anything to do with the case itself, and they have literally nothing to do with the decision you all are about to make. I'm not involved in that decision. You're the ones that are going to make that decision, and you should not take anything I do or say to indicate to you that I prefer one verdict over another, because I do not. I am completely neutral in this. It's your job to make the decision in this case, okay? Anyone have any questions? Yes, sir.
If I miss a word from anybody, who can I ask?
Raise your hand when you miss it and say, I did not hear that, okay? At the time you miss something because of the sound system, let me know. And really that is what stresses me out, is I'm sitting here wondering, can the jury hear what's happening? So if you can't hear or you miss something, raise your hand and let us know when it happens. We'll have the witness repeat their answer, all right? Is it better now that I've had the witnesses take their masks off? Oh, good, okay. Any other questions? No. All right, I wanted to chat with you all. It's been kind of a different morning for all of you. So I'm going to send you back into the jury room. We need to set up some technology stuff. Have a cup of coffee, relax. We're going to start the testimony when we bring you back in again. All right, thank you, folks. Okay, we have a discovery issue. Mr. Buxman?
Yes, Your Honor. One issue I just want to put on the record. I've provided a stipulation to the defense regarding the defendant's felon status. I believe Mr. Linton mentioned it opening for the purpose of count 5 potential firearm by a felon. Obviously, the court knows it's customary for that to be done. So the jury doesn't hear the details of the actual prior felony convictions. It's my understanding that the defendant has chosen not to enter into that stipulation. I just wanted that to put the record clear that it was discussed with him and that he understands that the state would be, I believe, entitled to then introduce a certified copy of the federal felony conviction for conspiracy to possess cocaine with intent to sell, the battery of a law enforcement officer, the instigating of mutiny conviction, because these are all felony convictions that I think that we would be entitled to introduce absent the stipulation to prove the felon status of firearm.
All right, thank you. Mr. Loyd? Are you going to talk to him about it? Okay. So I'll give you a minute to talk about that. Go ahead. He's going to sign it? Okay, great. All right, Mr. Lenneman, you mentioned there was a violation.
I believe Mr. Williams is actually checking on something regarding that.
Okay, no worries.
May I approach the court, Your Honor?
Sure. All right, we have Mr. Williams back in the courtroom. Mr. Lenneman, you have a motion?
Yeah, Judge. Last night, I sent an email to Mr. Williams because I was looking through Livengood's report, and I only had a few of the photos that she had taken.
Whose report? Do you have your mic on? The question we ask constantly in this court.
All right. So I emailed Mr. Williams last night and requested, because in her report, she says she has 33 photos. That
I
was
didn't hear whose report we're talking about.
Livengood.
Oh, Livengood,
Crime
okay.
scene. She took photos on the 15th. She
Okay.
was sent back to the scene and took photos on the 15th. She wrote in her report that there were 33 photos that
Okay.
were taken. I only have a couple of those photos. And so I sent an email to Mr. Williams, and Mr. Williams sent an email back that he had photos that were numbered from, I think, 14 to 33, and he was going to check to see what's going on with the rest. And it's my understanding that he doesn't have them, and I think he was going to talk to somebody right now to try to determine if they were found.
Mr. Williams?
Yes, Your Honor. Said investigation is complete. I just spoke to Ms. Livengood. I looked at the proofs of her photographs that were actually in Detective Cadiz's booklet that was brought up yesterday, and her report is inaccurate. She took 18 photographs of the Walmart parking lot. I have all 18 that she has, and they have been provided to the defense counsel. If asked about it on a stand, she would say that her report, what ended up happening was she took 30-something photographs on one roll, but they were of two scenes. The first part was the Walmart, and the second part was a separate, unrelated scene, and she added the total number of photographs and put that in her report, when in reality, the photographs from the Walmart were 18 and not 32.
All right, thank you. Mr. Lenneman, you requesting a Richardson hearing? Or are you satisfied with the explanation, which obviously you're going to be able to cross-examine on?
Right. I believe I am. I have to move because I believe that those photos existed, that for whatever reason, the police department have discarded them as part of this investigation involving the bullet entry
Involving the what?
the bullet entry to the wall, the bullet ricochet to the wall that was discovered on the other end of the parking lot.
At Walmart.
At Walmart.
All right, so this is a Richardson hearing now. And you're moving what? To exclude all of it? What are you moving for?
No, I'm moving, Judge, that for them to provide the photos because I believe they exist.
And the basis of your belief is the original report?
Correct.
Is there anything else that you have
No.
as the basis, just that original report?
That's it.
I just want the record to be clear. All right, thank you. Response, State.
Your Honor, I think the best thing to do is just for us to call CSI Livengood, have her testify.
All right.
May I do
Bring
that?
her in. Yes, sir.
We
Bring her
have
in.
CSI Livengood, please.
All right, this
Karen
testimony,
Livengood.
this testimony is for the purposes of the Richardson hearing only. I'm going to want her re-sworn in for the Richardson hearing, please. Thank you. We're going to re-swear you this morning. Okay, thanks.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do. Have a seat, ma'am. And if you'll swing that mic around to in front of you. All right. Mr. Williams, you may inquire.
Thank you, Your Honor. Tell us your name again, ma'am, please.
I'm sorry.
Tell us your name again, please.
Karen Livengood.
And Ms. Livengood, you testified as a state witness yesterday, is that right?
Yes.
I want to ask you some specific questions regarding your work as the lead crime scene investigator in this case. I'm looking at a report that you generated in this case, might be page 2, where it indicates that you returned to it's actually page 3, you returned to the Walmart that is the scene of the homicide in this case on January 15th of 2017. Do you remember doing that?
Yes.
And have you been able to take a moment if you need to, the location in your report that I'm referencing?
Yeah, that's what I'm trying to find.
Yes, ma'am. It's page 3 of 7, actually, at the bottom.
Got it.
So in your report, you indicate that, and I'm quoting, I took 33 additional photographs of the front northwest side of the Walmart. I departed at 8:10 hours, 08:10 hours. That's what your report says?
Yes.
All right. Have you had a chance to go back and look at your photographs from the scene that you took on January 15th?
Yes.
And is there a photograph in there that tells you that they were specific to January 15th?
Yes.
Which photograph is that?
It would be the gray card.
And can you just describe for the record what that is?
We issued gray cards, and we would put the date and the case number to take a photograph of. And then that way it's keeping in the same sequence of, if you're going to multiple locations, let's just say, or cases, different cases, you do a gray card for every single case, and it separates the cases.
All right. So were you able to see the gray card for January 15th, 2017?
Yes.
Is your report accurate that you took 33 photographs of the northwest side of the Walmart that morning?
No.
How many photographs did you take?
I took, can I look at my photos? Because I've got them.
Any objection, counsel? Go ahead, ma'am. I believe they start with DSC 14. Just count them up for us, please.
Okay, sorry.
That's okay. Have you had a chance to count them?
The ones at the Walmart?
Yes, ma'am.
Only?
Yes, ma'am.
Yes.
How many are there?
19.
19. Are there additional photographs from a different scene on that same roll?
Yes, but it was still related.
Okay. Do you know why you put 33 in your report?
Just showing how many photographs I took that day period.
Okay. So that was a mistake in your report?
Yes.
That's all I have, Judge.
Cross.
Good morning, ma'am.
Morning.
Now, in the course of your duties as a crime scene technician and the lead in this particular case, it's your testimony that you keep a particular card for a particular date of work done. Is that correct?
You talking about the gray card?
Yeah.
Yes.
Okay. So when you say gray card, what is the gray card?
It's actually a photographic card that has that gives the case number and the date.
Okay.
And it has my name on it. Okay. So it would show that I'm the one that did the photography.
Okay. And is that where the photos are kept on that?
Yes.
So it's some kind of electronic card that you can plug in somewhere and see the photos?
Yes, because the photos get saved onto a CD card type of thing, and they get turned into are downloaded to a station, a photograph station, and stored in our photo lab.
Okay. And are they stored based on the date?
I don't know how they're stored. You'd have to talk to somebody in the photo lab for that. I can't tell you that.
So although you take hundreds and hundreds of pictures throughout investigations, you don't know how they are stored?
I would think they would be stored by case number.
Okay. And who has access to those photographs?
Just the two people and the supervisor that works in the photo lab.
Okay. Does the lead detective?
No, he still have to get buzzed in by the photo lab people.
But I imagine if he was buzzed in, he would have access to look at those?
He could look at them, but every time we download photographs, we would, like in this particular case, a copy would go, a set of proofs would go to the lead detective on this case, in any case, for that matter.
And is ultimately all of those combined into a group that you would turn over to the state attorney's office?
I actually don't know how it gets sent to the state attorney's office.
So this gray card you're talking about is just something you write on?
That's correct.
Okay. And you put the date?
I put the date.
So I imagine you have a bunch of gray cards.
Well, you can wipe off the gray card. It's set up to where you can wipe off the date and the case number. It still has my name on it.
Okay.
And you reuse it over and over again.
Okay. So when you say you wipe off, that you can wipe off the information on the card?
Yes.
Okay. And do you save those cards?
Well, we all had one or two.
Okay.
So yeah, it stays with the our photography kit.
So when you referenced earlier in your testimony that you were able to tell the number of photos on the gray card, is that something you have on you?
I have a proof sheet.
Okay, but do you have the gray card?
Not with me.
Okay, you have the proof sheet of what?
I have the proof sheet and it shows the gray card.
Okay, and what's on the proof sheet?
Depends which one. I took a lot of different photographs in different areas.
Okay, so the proof sheet that you looked at where the gray card told you the number of photos you took on the 15th, do you have that?
Yes.
Okay, and is it connected with the number of photos that you took on that date?
That's correct, but not all in one location.
Okay. So how many photos are on that proof sheet that you're talking about?
For total?
Yeah.
Looks like 67.
Okay, and how can you tell which ones we're taking on the 15th?
I have it, I keep the batches together, and I have the gray card.
Okay. Judge, I'd ask to be provided those to make my decision about
Provided which?
what she has.
All 67 or the gray cards for the date in question?
All of them, because they're all together.
So you want to look at what she has with her?
Yes.
I don't have any objection to that.
No objection.
Go ahead. Ms. Livengood, could you hand that to the deputy? There you go. So for the record, you've handed him all the proof sheets for all 67 photographs taken in this case?
On that date.
On that date, which was?
15th.
January 15th, 2017?
Yes, ma'am.
All right, thank you.
You said you gave me the photos. Yeah, where did you give me the 19 photos and? Okay, so you. I don't have this. I'm going to withdraw the descriptive violation, but I need these photos for my cross of her at the, when she gets. Okay, okay, thank you. Okay. Okay. I have no further questions, Judge. Hold on one second.
Sure. Sure, of course.
Ma'am, I'm trying to understand why this group of photos begins with photo number 14. Where is 1 through 13?
Well, there are times when you get a call, a different case right beforehand, and I was going from another case and came to this one.
Right, but
So the photographs that lead up to this, I took 13 photographs on a totally different case that led up to this.
do you have proof of that?
No, I don't understand.
Do you have proof that you have 1 through 13 that would have been attached to these documents that show that you took 13 other photos and that they weren't 13 photos of Walmart?
No, I'd have to look at all my cases and find out what case I had before it.
How would you make a mistake where you start this at 14?
It's not a mistake. I went from a call that was down the street to the Walmart. I never went back to the station, so I couldn't download the photographs beforehand. And that's not uncommon when you go to different calls. So the 1 through 13 is from a totally different call. That's why it starts at 14. For this case, this gray card started at 14.
Okay.
Because it was not done all on the same day, the first day.
Okay.
So I can't guarantee what number it's actually going to start. That's the purpose of the gray card.
Okay. And so when you made the mistake of putting down 33, it was based on that the last photo you took in there was 33 in that particular collage of Walmart.
It could have been, I don't remember why I put 33.
All right. I have no further questions, Judge.
Thank you. State, any redirect?
I get to use them.
These are
No, Your Honor.
mine.
Oh, yeah, but I get to give them back to you. Thank you.
What are we doing here?
I'm trying to get these photos back because I'm going to use them, Judge.
Well, hold
With
on.
permission of him during the cross.
Does Ms. Livengood need them during her direct? I don't have an issue with you using them during cross, but
You wanna use them?
these are part of the witness's package that she brought with her, so.
No, Your Honor, the direct that she's going to undergo does not involve these photographs or anything she did on January 15th.
All right, thank you. So do we have any redirect on the issue, the Richardson issue?
No, Your Honor.
Okay. Argument, state.
I think the record is clear. The witness has testified that she took 19 photographs on January 15th, that she made an error counting in her report, and that all the photographs have been provided to defense counsel. So I do not believe there is a Richardson violation whatsoever, let alone the second and third and fourth prongs.
Mr. Lenneman, argument?
No argument.
Okay, court finds as follows. If you add 14 and 19, it equals 33. The last numbered photograph, according to you, Mr. Lenneman, is 33.
Yes, ma'am.
The witness has testified that it's a mistake. It appears to the court that she simply made a mistake in her report, so I do not find a Richardson violation at this time, since you were provided the 14 through 33. All right, thank you very much. Is she your first witness? Or are we taking her off the stand and bringing somebody else in?
We're doing it the hard way, Judge. We're taking her off.
All
and
right,
bringing
Ms.
somebody else.
Livengood, we're going to get your steps in today. You may step down. You know what, folks? I need a 10-minute break, so we're going to take a 10-minute break before we start. Court's in recess. Sorry to keep everybody waiting. I had another issue I had to take care of. All right. Let's bring the jury back in. State recognized presence of the jury.
We do, Your Honor.
Defense?
Yes, yes.
All right, welcome back. I'm sorry to keep you all waiting. We try to get all the legal stuff and all the technological stuff out of the way while you were back there so we don't have to keep bringing you in and out, and so that we can just roll through the testimony this morning. I've also made an executive decision to tell the lawyers, take your masks off when you're asking questions so that folks can hear you. All right, State, you may call your next witness.
State recalls Detective Pete Cadiz.
No, you need to re-swear him. It's been a while. Yeah.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, have a seat, sir. You may inquire.
Thank you, Your Honor. Welcome back, sir.
Thank you.
The last time you testified, Detective, it was regarding your activities up to the point of the apprehension of Mr. Loyd at Lescott Lane. Do you recall that?
Yes, sir.
Before we discuss your investigative activities going forward from that point, yesterday afternoon, did you bring to my attention a mistake in your testimony from yesterday?
Yes, sir, I did.
Can you tell the members of the jury the mistake and why you made it and what it was?
So after my testimony yesterday, I was going over my notes, going over all the various reports that had been submitted, and I had testified yesterday that Detective Overfield had done a supplement report, referenced the projectile that had been found in the parking lot, and upon reviewing, it was determined that CSI Livengood had actually done the supplement report.
So based upon your review, Detective Overfield did not do a supplement report, correct?
That's correct.
And it was actually done by Ms. Livengood?
Yes, sir.
Okay. Now, going back to Lescott Lane on January 17th of 2017, at some point later in the evening, did you go out to the Lescott Lane residence?
Yes, sir, I did.
And did you assist in executing the search warrant in the residence?
I did.
And by executing a search warrant, I mean you looked around for potential evidence. Is that right?
That's correct.
All right. Were you present when a piece of phone was found in the toilet of one of the bedrooms?
Yes, sir, I was.
Now, which part of the phone was located?
So this was a flip phone, so it's a two-piece phone. The top screen portion, you could see visually in the toilet.
When the top screen portion was located that night was the bottom portion found?
It was not.
At some point, did you and other members of your team decide that you needed to take steps to find the bottom portion of the phone.
Yes, sir, we did.
So what steps were taken and by whom to try to find or assist with finding the remainder of the phone?
So a team from wastewater management came out to the scene, and they used a optic camera to go down the plumbing to search visually down there to see if it had made it down that far down. We didn't discover the phone at that point. I took one of their hammers and basically went to the toilet and crushed the toilet, and the little circle trap, the bottom portion of the phone, was found in there.
Sir, may I approach the witness to what's been previously marked as State's Exhibit AN and shown to counsel?
You may.
Your Honor, AN is a composite of 4 photographs. Detective, could you look at the 4 photographs in State's Exhibit AN and tell me if you recognize the image depicted in them?
Yes, sir, these are pictures of the destroyed toilet with the bottom portion of the phone in the trap.
The toilet you destroyed and the phone you found?
Yes, sir.
Did they fairly and accurately represent your actions on that day?
They do.
Your Honor, at this time, I'd ask the court to admit State's AN. Thank you, sir.
Any objection? No objection. All right, this will be admitted without objection as State's Composite Exhibit 52, consisting of 4 sequentially numbered photographs.
Your Honor, permission to publish State's Exhibit 52?
Granted.
Now publishing photograph number 1. Can you tell us what we're looking at in the photograph, Detective?
So the residence has a bedroom, a main bedroom with an attached bathroom to it. This is the toilet in the attached bathroom.
Now, when the search warrant was initially executed, was the toilet on its side like that?
It was not.
Who did that?
I did.
With the hammer?
Yes, sir.
Photograph number 2 of State's Exhibit 52. What do you see in that photograph, sir?
It's the side of the toilet and the side of the trap where I hit it with the hammer, and the bottom portion of the phone.
Photograph number 3, is that a close-up of?
Yes, sir.
What is it a close-up of?
That's a close-up of the bottom portion of the phone.
And photograph number 4.
Again, close-up of the bottom portion of the phone.
The only other question I have for you, Detective, is yesterday afternoon, I believe, defense counsel asked you some questions about a warrant for Facebook materials associated with Mr. Loyd. Do you remember that question?
Yes, sir.
I believe your response was that you were aware that Facebook materials were obtained, but you were not involved in getting them.
Correct.
It's right here. I got it. Your Honor, at this time, the state would ask the court to admit State's Exhibit BF as the next numbered exhibit. It has a business record certification. A notice was filed, and I believe there's an agreement as to authenticity.
There's Facebook?
I'm sorry?
Is that Facebook?
Yes.
Okay. Any additional objections?
No additional objections.
All right. Over the objections of the defense, this will be admitted as State's Exhibit number 53, composite exhibit consisting of how many pages, Mr.? 11 pages. Thank you.
No further questions, Your Honor. Thank you, sir.
Cross, Mr. Lenneman? All right. Thank you, Detective.
Thank you, Judge.
Is he excused and released or just excused?
Just excused.
All right. You're still subject to recall.
Yes,
Thank
ma'am.
you. Call your next witness.
Your Honor, the state recalls Karen Livengood. Karen Livengood. Here. Oh, you got it? Okay.
Ma'am, you remain under oath.
Okay.
You may inquire.
Thank you, Your Honor. Good morning.
Morning.
Ms. Livengood, when you testified yesterday, you told us, amongst other things, about your activity in collecting evidence at the scene at the Walmart on Princeton Street, correct?
That's correct.
And we saw a number of photographs that you took of particularly the parking lot at the Walmart scene. Do you recall that?
Yes.
And some of those photographs were of what you described as spent casings. You recall that?
Yes.
May I publish State's Exhibit 31?
You may.
It's the diagram. I'll tilt it for you, Ms. Livengood, but do you generally recall the diagram?
Yes.
All right. So you can see it, Counsel. Yeah. Now, you also testified, I believe, that you recovered amongst the casings 2 different calibers of casings. Is that correct? From the Walmart parking lot?
Yes.
And what were the calibers of casings that you recovered?
The 9 mils were the Winchester 9 mil Lugers, and then there was several different of the 40 caliber.
Right, so I don't need to know the manufacturer, but you collected 9mm casings and 40 caliber casings.
That's correct.
Your Honor, may I approach the witness of what's been marked as State's Exhibits AV and AW?
You may.
Ms. Livengood, I'm going to start with State's Exhibit AV, actually. I'm going to hand you a package. Do you recognize that?
Yes.
And what do you recognize it to be?
These are going to be the 8 spent 40 caliber.
So you packaged every 40 caliber casing that you recovered from the scene in the same package?
They're in individual packages inside of this package.
Okay. And how do you know that, and how do you recognize that specific package?
Well, it has my name on it. I mean, it has the detective's name on it and the case number, and that's my handwriting.
All right. I'd like you, if you wouldn't mind, just to open that up with some scissors.
Sorry.
Oh, is it already open?
Oh, I think it just ripped.
Okay.
But
And just take the scissors and open it up and make sure that what you believe to be in there is in fact in there.
yes,
Do those casings appear to be in the same or substantially same condition as they were when you packaged them, but for having been sent to the Florida Department of Law Enforcement?
yes,
I'm now going to hand you, if you could just push them back in the package, State's Exhibit AW, trade you. Same thing, you see your name on the outside of the package?
yes.
And what do you recognize that package to be?
This is the 9 mils, 8 9 mils
Right.
that were from the scene.
And if you need to open it up, you have your scissors up there?
Yes,
And just look inside and make sure that it is in fact the 8 9mm shell casings.
yes,
Same question, do they appear to be in the same or substantially same condition as they were when they left your custody, other than they've been sent to the FDLE?
yes.
Your Honor, at this time, I'd ask the court to admit State's Exhibits AV and AW as the next numbered exhibits. Thank
Any
you.
objections?
No objection.
All right, AV will be received as State's Exhibit number 54, and AW will be received as State's Exhibit number 55. They are composite exhibits containing multiple rounds.
So in total, then, you collected 8 9mm shell casings from the parking lot of the Walmart. Is that right?
Yes,
And 8 .40 caliber casings from the parking lot.
yes.
I don't want to gloss over this. Can you tell the members of the jury how you go about collecting the shell casings? In other words, describe how you physically pick them up and put them in the packages, please.
Once the photography is done, I wear gloves, and I mark on the individual little envelope that I'm going to put each individual casing in, and then it gets sealed, and my initials go on that envelope.
All right. Now, once you collected the 2 exhibits, 54 and 55, did you send them to the Florida Department of Law Enforcement for testing?
Yes.
What type of testing does FDLE do on spent cartridge casings, just generally?
I really can't, I don't know that.
Are they able to compare them to known firearms?
Yes, if they've got it, yes.
Yes, ma'am. In addition to the shell casings, did you also collect some other firearms-related evidence from the scene?
Say that again?
Sure. In addition to the shell casings, did you collect other firearms-related evidence?
Yes.
From the scene? All right. What types of evidence did you collect when I say firearms-related?
Projectiles,
All right.
pieces of.
Gentlemen, I approached the witness, would have been marked as State's Exhibits AS, AT, AX, AU, and State's Exhibit 34. May I approach, Your Honor?
You may.
They've all been shown to counsel. I'm going to hand you each one, and then I'm going to ask you just to say and describe what it is, and then we'll go through the boring questions at the end, okay?
Okay.
Yes, ma'am. First exhibit is AS. Can you tell us what that is?
This is going to be a piece of lead that was located on the ground at one of those tent markers that I have of P.
All right. Just one moment. Okay. That's as to AS. Now, I'm handing you AT. What is AT?
This one's going to be a projectile at marker cone Q that was located on the pavement.
And that's the projectile that was not initially seen, but that was then found and photographed?
Yes, yes.
Now handing you AX.
This is going to be a copper jacket that was located on the right front passenger floor, and this is going to be cone T.
And that would be the floor of the Mercury that
Yes,
we saw
yes,
the
sorry.
photographs of?
Yes.
Yes, ma'am. And if I'm right, each of these, you actually wrote the description on the outside?
That's correct.
Okay. And AU now, could you tell us what that exhibit is?
Copper jacket, it's going to be cone S, located on the ground, southwest of the north entrance.
And finally, State's Exhibit 34, which is already in evidence. Can you tell us if you recognize the handwriting on the outside of that?
Yes, this is my handwriting.
All right. Now, did you collect that actual exhibit?
No.
What is State's 34?
It is a projectile that Detective Overfield had collected and brought to me.
All right. And did you document that in your report?
Yes.
Your Honor, at this time, I'd ask the court to admit, are all of these in the same or substantially same condition as they were when they left your possession after packaging them other than they've been to the Florida Department of Law Enforcement?
Yes.
Your Honor, at this time, I'd ask the court to admit states exhibits AU, AX, AS, AT, and 34 is already in evidence.
Any objections to any of these? All right. These will be admitted without objections. AS is number 56. AT is number 57. AU is number 58. Did I skip AX? AX is 59 then. All right.
May I proceed, Your Honor?
You may. All right.
Again, were all of those projectiles or fragments of projectiles sent to the Florida Department of Law Enforcement for testing?
All the casings I know for sure went.
Sure. Would it help you to look at the actual items to see if they went to FDLE?
Yes, better.
While we're waiting for that, I'll ask you a couple of additional questions. Leaving the Walmart for a moment, you testified yesterday that you additionally went to the Royal Oaks apartment complex to take photographs and collect evidence at the scene where the incident with Captain Carter occurred.
Yes.
Did you also collect a spent casing from that scene?
Yes.
Your Honor, may I approach the witness to what's been marked as State's Exhibit AY and shown to counsel?
You may.
Ms. Livengood, I'm showing you what's been marked as State's Exhibit AY. Do you recognize it?
Yes.
And what do you recognize it to be?
One spent casing, and it's a 9mm Luger, and it's marked with the tent cone AC.
Okay, can you go ahead and open that up? Let's just verify that that's what's in there, please.
Yes.
Is it in the same or substantially same condition as it was when it left your custody, other than having been sent to the Florida Department of Law Enforcement?
Yes.
Your Honor, at this time, we'd ask the court to admit State's Exhibit AY as the next numbered exhibit.
Any objections?
No objection.
This will be admitted without objection as State's Exhibit number 60.
Your Honor, may I approach the witness again?
You may.
And I'm specifically approaching with State's Exhibits 57, 58, 59, and 56. So if you recall, I had asked you the question about whether they had been to FDLE.
Yes.
My understanding is that FDLE puts a yellow sticker on it when it goes there. Does that sound right?
That sounds about right. Yeah.
Right. State's Exhibit 57, was it sent to FDLE?
Yes.
State's Exhibit 58, was it sent to FDLE?
Yes.
And Exhibit 59?
Yes.
It looks like, what about 56?
Yes.
Okay. That's all the questions I have, Your Honor.
Cross?
Judge.
You may inquire.
Good morning.
Morning.
How are you?
Good.
So your responsibility is to collect stuff. Is that pretty much what you do, and take photos and document, memorialize, correct?
Collect, photograph, yes.
Okay. And so all these casings and projectiles that were found at the Walmart, those are all bagged up and sent to the Florida Department of Law Enforcement.
That's correct.
You don't compare the casing to the actual gun?
No,
Okay, that's not your responsibility.
no,
That's what they do at FDLE.
that's correct.
And so in this particular case, there were 3 guns that were collected in this investigation. Is that right?
Yes,
Okay. 2 where Mr. Loyd was arrested, a Luger and a .40,
okay,
and then her gun, a 9 SIG.
that's correct.
Correct? And so what happens at the Florida Department of Law Enforcement is they take the gun and test fire it, and then they match casing to gun. Correct?
Okay, I don't know, but yes.
Okay. Okay. But that's not your responsibility.
No, sir.
I have no further questions, Judge.
Thank you, Mr. Lund. May this witness be excused?
No.
All right, ma'am, you're free to go forward today, but you remain under subpoena and subject to recall. Thank you. Call your next witness.
The state calls Richard Ruth.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, sir. You may inquire.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please tell us your full name and spell your last name?
Richard Ruth, R-U-T-H.
And Mr. Ruth, where are you currently employed?
I'm employed with the Bureau of Alcohol, Tobacco, Firearms, and Explosives in Huntsville, Alabama.
And how long have you been employed by, I'm going to use ATF for short?
I've been employed with the ATF for approximately 2 years this January.
What do you do for ATF currently?
I'm a firearms examiner in the NNCTC, the NIBIN National Correlation and Training Center.
Prior to working as a firearms examiner at ATF or the ATF, did you work at a firearms examiner elsewhere?
I did. I was a crime laboratory analyst with the Florida Department of Law Enforcement, or FDLE for short.
Can you describe what it was, well, before that, how long did you work as a crime laboratory analyst for FDLE?
From 2016 to 2019, and prior to that, I was a forensic technologist from 2012 to 2016.
Can you describe what you would do on a daily basis as a crime laboratory analyst in the firearms section when you worked at FDLE, please?
My primary responsibility was examining firearms to determine their functionality, as well as examining fired ammunition components using a comparison microscope to determine whether or not those units of ammunition were fired from a particular firearm. My administrative responsibilities also involved peer reviewing my peers' case files, both technically and administratively.
Now, can you tell us about your education and then your training that is relevant to your current role in firearms and the role you had as a firearms examiner at FDLE?
I have 2 bachelor's degrees. I have a Bachelor of Science in Astronomy and a Bachelor of Arts in Physics from the University of Florida. That provided a physical science background for me to become a forensic scientist. My training to be a firearms examiner was an 18-month training program from the Florida Department of Law Enforcement that allowed me to perform those job responsibilities.
Can you give us an overview and sort of walk us through the training process, the 18 months at FDLE, please?
My training was broken into two portions. When I first started with the firearms section, it was as a forensic technologist. That was my first 6 months of training. That taught me the different types of firearms, how they function, and how to safely test fire them to determine if they are functional. When I became a crime laboratory analyst, that was an additional 12 months of training that was focused on how to use a comparison microscope. I was taught how to compare cartridge cases and projectiles to one another and to determine if they were fired from a particular firearm. I also underwent training to perform what's called distance determination. That's examining gunshot residue on objects to potentially determine a distance from which a firearm had expelled a projectile.
So after FDLE trained you, do they just send you out into the world, or do you have to pass some tests in order to be able to do your job?
My training involved both practical and written examinations prior to moving on to supervised casework. Once I successfully passed my competency tests, I had to undergo several months of supervised casework where I performed my work under the supervision of a senior crime laboratory analyst prior to results going to our customers. Once I completed my supervised casework portion, I also had to undergo a mock trial prior to performing my own casework independently.
Now, once you finish supervised work and your work is no longer supervised, is your work still reviewed?
Yes.
Can you explain to the members of the jury how your work as a firearms analyst at FDLE was still reviewed on every case that you worked?
So after I complete my examination, I have to document everything that I observed during the course of my examination on any evidence that I performed. My case file would then be submitted to a peer for what's called technical review to make sure that I followed standard operating procedures and that I did everything correctly as indicated by my notation. It would also go to another analyst after that for an administrative check where my report was reviewed against my notes to make sure that the report accurately reflected the results of my examination in my case notes. At that point, the report would then be released to our customer agencies.
When you were at FDLE, did you continue to receive education and training updates even after you did your own unsupervised casework?
I did.
Were there any studies or publications that you would review on a regular basis to make sure you stayed up to date on the technology as it advances?
So I would review what's called the Association of Firearm and Toolmark Examiner publication. A quarterly journal was published with peer-reviewed research. I would review those articles as they were released to stay current on developments within the firearms identification field. I would also attend conferences held by the Association of Firearm and Toolmark Examiners, as well as discipline meetings for the firearms section that FDLE would hold for our state agencies.
And are you a member of any professional organizations that focus on firearms, firearm identification and function?
I'm a regular member of the Association of Firearm and Toolmark Examiners.
Now, during your time as a firearms analyst at the Florida Department of Law Enforcement, Mr. Ruth, did you have the opportunity to provide opinion testimony in the area of firearms function and identification in the courts of Florida?
I did approximately 25 times.
Your Honor, at this time, the state would ask the court to allow Mr. Ruth to provide opinion testimony in the area of firearms identification and function.
You wish to? All right. You may proceed.
Thank you, Your Honor. Generally speaking, what is a firearm and how does it work?
A firearm is a device that's designed to expel a projectile through the action of an explosive. Generally, that's done by firing what's called a cartridge. A cartridge is a single unit of ammunition. It's composed of a cartridge case, a primer, gunpowder, and a projectile that's seated in the mouth of the cartridge case. The cartridge is loaded into the firearm. It's struck by a firing pin of some type, and that ignites the gunpowder within the cartridge case. That gunpowder is converted into a rapidly expanding gas, and that gas pushes the projectile down and out the barrel of the firearm.
So what portion of the firearm that you just described is commonly known as the bullet, if you wouldn't mind?
So people commonly refer to the entire cartridge as a bullet, saying, was the gun loaded with bullets? That's the entire cartridge itself. The bullet is actually just the projectile that's seated at the mouth of the cartridge case, the projectile itself.
So can you tell us how many general types of handguns exist?
They can be broken down into two categories, revolvers and semi-automatic pistols. The difference between the two is that a revolver has a cylinder with multiple chambers within it, whereas a pistol has a single chamber.
Does a revolver differ from a semi-automatic as to how the casings are removed from the firearm after the projectile is fired?
It does. A revolver, you have to open the cylinder and swing it outward, and you have to manually load a cartridge in each one of the chambers and then close the cylinder within the firearm. When the revolver is fired, the cartridge cases remain within that cylinder until you open it, and it has to be manually removed from the cylinder, each one of them by hand. With a semi-automatic pistol, the cartridges are loaded into a magazine, and when the firearm is discharged, everything happens automatically. The force of the firing process drives the slide to the rear, automatically extracting and ejecting a cartridge case. It loads the next one so that you're ready to fire the pistol again.
Now, what is it about, before I ask that question, are you able to say, even generally, where a casing will be ejected from a semi-automatic firearm?
It's really difficult to say. Generally, it's extracted and ejected out the side of the ejection port of the pistol, but FDLE didn't perform ejection pattern analysis because of how many variables are involved. If the gun's held upright, generally the cartridge case is extracted and ejected outward to the right. But after that, the cartridge case could bounce, depending on what surface it's rolling on. It's really difficult to say where a cartridge case would be after that point.
So earlier you talked about a microscope and using a microscope to compare firearms and cartridges. What is it about how a cartridge interacts with a firearm that allows you to make observations and do that comparison? If you could describe that, please.
The principle of firearms identification all relies on the manufacturing process of the firearm, as well as its continued use or abuse. When a firearm is manufactured, it undergoes many different tooling processes. This is done to finish the firearm, put rifling in the barrel to make surfaces smooth. But during that manufacturing process, it's not a perfect cut or a perfect mill. As firearms being manufactured, the tools undergo wear, and when it's cutting metal, it's really not a cutting, it's more a tearing process. So during the manufacture of that firearm, there are microscopic imperfections that are imparted to the firearm that remain with it. And these can change slightly over time with continued use and abuse of the firearm as the metal wears. Cartridges are a softer metal, so when ammunition is fired in something like a pistol, the harder metal of the firearm can impart those random and microscopic imperfections from the firearm into the softer metal of the cartridge, whether that's the primer, the cartridge case, or the projectile itself. It leaves a signature of sorts on the cartridge.
Are you familiar with the term individual characteristic and the term class characteristic?
Yes. Class characteristics, those are things that are determined by a manufacturer prior to the gun being produced. That could be the size of the ammunition that's going to fire, the diameter of the barrel, the number of lands and grooves that are in the rifling. Those are all things that are determined prior to manufacture. Individual characteristics, those are those random and unique microscopic imperfections that are outside the control of the manufacturer that arise from the manufacturing process that leave a unique signature for each firearm that essentially can't be controlled by the manufacturer.
So can you describe what you look at and what tools you use when you look at casings, projectiles, and firearms to compare or tell whether a firearm fired a specific projectile or ejected a specific casing?
I use a comparison microscope. It's the easiest way to define it is that it's two separate microscopes that are joined by an optical bridge in the middle. And what I do is I look through an eyepiece, kind of like a set of binoculars, where I can put one item under one microscope and another item underneath the second microscope. And in looking through the eyepieces, they appear as if they're side by side to me. And I can look at those imperfections on either a bullet or a cartridge case and see if there's any kind of agreement in those imperfections that have been imparted to the ammunition components.
So let's talk specifically about casings for a moment. What impact is performed on a casing by a firearm that allows you to tell if a casing was inside and ejected from a specific firearm?
During the firing process, that same, when the gunpowder is ignited and is converted to a gas and it pushes the projectile out of the barrel, that force actually acts in all directions and it drives the cartridge case rearward into the portion of the pistol called the slide. The manufacturing marks on the slide itself, that portion that's in contact with the head of the cartridge case, they'll be imparted into the primer and the softer metal of the cartridge case during the firing process. The cartridge case is then extracted and ejected, which also leaves another set of marks by the extractor and ejector of the pistol on that cartridge case. It's those markings that I'm looking at that can determine whether or not that cartridge case was fired from a particular gun.
So if you have a firearm that's been given to you for comparison, how do you know, or how do you generate a model, so to speak, from a firearm and a casing to compare to casings that are located elsewhere?
What I'll do with the firearm is I will generate my own standard. When a firearm is submitted to the lab, I test fire that on my own so that I can get a sample from that firearm. With the sample in hand, I can compare that using a comparison microscope to a question item, a piece of evidence that is submitted to me, to see if there's enough similarities between the evidence and that test-fired sample that I generated myself.
And last question before we move to the evidence in this case. You described the process of what marks are left on a casing. What marks are you looking for on a projectile or what's commonly known as the bullet?
On a bullet, the marks that are left on that arise from the rifling of the barrel. It's a series of lands and grooves that are in a spiral pattern. The purpose of that rifling is that as the projectile goes down the barrel, the rifling grips the bullet and it imparts a spin to it, kind of like throwing a football. The football will fly much better in flight if it has a spiral to it. So that's what the purpose of the rifling is for a bullet. But it also leaves behind those individual characteristics on the bullet, not just the lands and grooves, but what appear to be scratches under the microscope, very fine scratches down the side of the bullet. I'm comparing the marks within the rifling to one another from a test fire to a evidence bullet.
Okay, so now, do you have your case file with you?
I do.
While you were employed with FDLE back in 2017, did you come to examine some items and render some conclusions in two FDLE case numbers? The first was 2016-05-14766, and the second is 2017-05-00342.
I did.
And did you author multiple reports regarding some of the information or evidence you obtained?
I did.
So I'd like to talk to you first about your report that's dated February 2nd of 2017. Did you receive a 9mm Luger caliber Sig Sauer model P226 for testing and comparison purposes?
Yes.
Your Honor, may I approach the witness for what's in evidence at State's Exhibit 28?
You may.
I just asked you, Mr. Ruth, if you received, and there are gloves on your left if you need them, I don't know that you will. If you received a Sig Sauer firearm, and you said yes, could you take a look at that box, open it up if you need to, and tell me if that's the same Sig Sauer that you received and tested?
It is.
And how do you know that it's the same firearm?
I recognize both the evidence packaging as well as the firearm by the unique FDLE case number, the exhibit number, as well as my initials that I wrote on the box, as well as the evidence within the box.
When you say you wrote your initials on the evidence in the box, what do you mean by that?
I used a paint pen and I wrote down the FDLE case number, exhibit number, and my initials within the magazine well of the pistol.
May I approach the witness, Your Honor?
You may.
Mr. Ruth, I'm going to hand you what's been placed into evidence as State's Exhibit 55, represented as 8 spent Winchester 9mm casings. Do you recognize State's Exhibit 55?
I do.
And have you done or performed some analysis on the 8 cartridge casings in State's Exhibit 55?
Yes.
Now, the firearm that you received has the word Luger in it. What does Luger in that title represent?
So a pistol such as this one, it's a 9mm Luger caliber. There's many different cartridges that have a bullet diameter of 9mm. It's a caliber family. The Luger is just the name that's applied to this specific cartridge or the type of ammunition that this pistol is designed to fire.
Now, did you compare that firearm in front of you to the 8 shell casings represented as collected from the Walmart scene in this case?
Yes.
And can you tell the members of the jury the results of your comparison or your findings, please?
After test firing this pistol and comparing the test fired cartridge cases from it to these cartridge cases here, it's my opinion that these cartridge cases were fired within this pistol.
Now, in that same report dated February 2nd of 2017, did you receive a 9mm Luger Glock Model 17 semi-automatic firearm for comparison purposes?
Yes.
May I approach the witness, Your Honor, with State's Exhibit 44?
You may.
I'm going to leave that firearm with you because I'm going to ask you another question in a moment.
Okay.
Please. I'm showing you or handing you what's been marked or placed in evidence as State's Exhibit 44. Do you recognize State's 44?
I do.
And what do you recognize it to be, sir?
I recognize it to be that Glock Model 17 that was submitted to the laboratory by those same markings, the FDLE case number, exhibit number, and my initials on the packaging, as well as on the firearm itself.
And did you compare that firearm to what was represented as a spent Hornady 9mm casing?
I did.
Now, may I approach the witness of what's been marked as State's Exhibit 60?
You may.
I'm handing you what's been marked as State's Exhibit 60, Mr. Ruth. Do you recognize State 60?
I do.
And how do you recognize it?
I recognize it by my markings on the packaging, the FDLE case number, exhibit number, as well as my initials.
Could you read the description on the outside of where it's from in black marker?
It's one spent casing, Hornady 9mm Luger, cone AC, located in the parking lot northeast of left rear tire of Mercury at 4801 North Pine Hills Road.
Did you compare the casing within that exhibit to the firearm, the Glock firearm in front of you?
I did.
Could you tell the members of the jury the results of your comparison?
It's my opinion that this cartridge case was fired within this Glock pistol.
All right. 34. I'm going to hand you now State's Exhibit 34. I'm going to take the Glock firearm and the casing. Tell me if you recognize State's Exhibit 34.
I do.
And what do you recognize it to be?
I recognize it to be a projectile that I examined within this case.
Did you perform any testing on that projectile?
I did.
Did you compare it to any firearms?
I compared it to the firearms within this case.
Could you read the outside of that package for that projectile?
It's one projectile collected by Detective Overfield, located by the south entrance at 3101 West Princeton Street.
Now, and if you need to open it up and look inside, that's fine, but can you describe the condition of that projectile?
The condition of this projectile is very poor. Some of it is missing. It appears to have struck an object, causing pretty severe damage to it. It's fairly distorted in appearance and also has a lot of damage to it from striking an object.
So you said that you compared that projectile to, I think you said firearms, multiple, is that right?
That's correct.
Did you compare it to that Glock 9mm firearm that you had a moment ago?
I did.
And did you compare it to a .40 caliber firearm that you received?
I did.
Finally, did you also compare it to the Sig Sauer firearm that is still in front of you?
That's correct.
Can you tell the members of the jury the results of your comparison as to that projectile, please?
The first comparison I made to that Glock firearm, my conclusion was that it could not have been fired from the Glock due to differences in the rifling characteristics. A different method was used for the rifling. This has what's called conventional rifling on the bullet. The Glock does not. It has what's called polygonal rifling. So I don't believe that this bullet was fired from the Glock. The Sig Sauer pistol that we have here, the class characteristics are similar. They both have conventional rifling. The actual width of the rifling imparted on this bullet was similar to the pistol, but due to its condition, I couldn't identify it as having been fired from this pistol or eliminate it as having been fired. This is what we call a neither nor inconclusive result. I can't say definitively if it was or was not fired from the pistol. The other pistol that I compared it to, it also had conventional rifling, but the width of the rifling was different. Therefore, I believe it was not fired from that other pistol yet.
So finally, as to the firearms, did you receive a 40 S&W caliber Smith & Wesson model SW40VE semi-automatic firearm for testing and comparison purposes?
I did.
I'm going to provide you or hand you State's Exhibit 43. If you could hand me 34, and I'm also going to take back State's Exhibit 28. What do you see, and do you recognize State's Exhibit 43?
This is the Smith & Wesson SW40VE semi-automatic pistol. I recognize it by the case number, exhibit number, as well as my initials that I placed on the outside packaging, as well as the pistol itself.
And did you also receive 8 spent casing, .40 caliber, represented as collected from a parking lot of West Princeton Street?
Yes.
May I approach the witness, Your Honor? Exhibit 54.
You may.
I'm handing you State's Exhibit 54. Mr. Ruth, could you just humor me and read the outside of the package, please?
This is described as 8 spent casings, .40 caliber, various manufacturers. Marked cones A, F, J, L through O, and R, collected from parking lot at 3101 West Princeton Street.
Did you compare those shell casings to the .40 caliber firearm that is in front of you?
I did.
And what were the results of that comparison?
It's my opinion that these 8 cartridge cases were fired from this .40 Smith & Wesson caliber SW40VE semi-automatic pistol.
And lastly, sir, may I approach, Your Honor?
You may.
Hand you State's Exhibit 35. Do you recognize State's Exhibit 35?
I do.
And what do you recognize it to be?
It's a projectile that was recovered. Should I read the label on this as well?
Yes, sir, please do.
Label as the projectile recovered from right arm.
And did you compare that projectile to the .40 caliber firearm to see if it was fired by that gun?
I did.
And can you tell the members of the jury the results of your comparison or your conclusion, please?
It's my opinion that this projectile was fired from the Smith & Wesson SW40 VE pistol.
Then there are also May I approach, Your Honor?
You may.
I'm going to hand you State's Exhibit 24. And again, could you read the outside of the package?
Yes. I recognize this one as well from my initials and case number, exhibit number on the packaging. This is described as 2 projectiles collected by the medical examiner from Officer Debra Clayton.
And did you compare the projectiles in State's Exhibit 24 to the .40 caliber firearm in front of you?
I did.
And what were the results of your comparison, please?
It's my opinion that these projectiles were fired from this pistol. One of them, I believe, was a fired bullet jacket. I identified that one. I believe there was a bullet core that I couldn't do anything with, but then another fully intact projectile that was identified as having been fired from that pistol.
No further questions, Your Honor. Thank you, sir.
Thank you. Cross, Mr. Weatherman.
May I collect the evidence, Your Honor?
You may.
From the witness.
Mr. Letterman, do you need it up there? He actually.
Would you like to see it, sir?
Yeah.
I don't need to see the gun. I just need to ask you a question. Good afternoon, sir. How are you?
I'm doing well. Thank you.
Good morning. I'm sorry.
Good morning.
All right. So an important part of your job is to obviously collect this important evidence of casings and projectiles and try to match it to a gun, correct?
Yes.
Okay. Sometimes that's not possible because a projectile may be damaged, so damaged that you can't say for sure, correct?
That's correct. Damage, it can inhibit my examination. If it removes those individual characteristics, it may not be available for comparison anymore, and it's a hindrance to the examination.
But you actually have a process you work through to try to attempt to do that, to identify that to a particular gun. Isn't that right?
When I get a piece of evidence, I evaluate it for the presence of individual characteristics before moving on to the comparison procedure.
Okay. And so when we're talking about a 4 HP pedal observed in the bullet type, what does that mean?
So when I'm looking at the evidence, the very first thing that I'm doing is just noting down my observation of what the actual evidence is. In this case, noting 4 HP pedals, I'm counting how many pedals are present on what is a hollow point bullet. That's what the HP stands for.
Okay, and we're going to get back to that in 1 second. There were 3 guns that you compared in this particular case, is that right?
Yes.
Okay. And in your report, you have them identified by a Q, correct? Q2, Q3, Q4?
Yes.
Okay. And one of the guns was a 9mm Luger caliber Glock Model 17. Is that correct?
Yes.
Okay. That particular gun was the gun that was fired at, I think you had said a particular, I don't think I have it written down here. 1 second. That one was one that was fired at a scene away from Princeton, correct? It wasn't at Princeton Street.
That's correct.
Okay. And you also matched it to one casing.
The Glock was matched to one casing,
Okay.
yes.
And you obviously don't know the facts about this case in regards to who was where and when people were shot and that kind of things, correct?
Correct.
Okay. But in that particular one, there was only a casing identified to one bullet, correct?
One casing identified to one firearm.
Okay. And that firearm was that 9mm Luger that you're talking about?
The Glock Model 17?
Yeah, the Glock Model 17.
Yes, sir.
That's not the gun that Lieutenant Clayton had, correct?
No, Debra Clayton's gun, I believe, was the 6-hour P226 semi-automatic pistol.
So we're not confused. There's 2 9mm, but one's a Luger and one's a Luger caliber 6-hour, correct?
Correct. 1.9 Glock and 1.9 6-hour, same caliber.
And hers was the 6-hour, correct?
Yes.
Okay. And so when you were shown exhibit number 55, which is 8 spent casings, Win 9mm Luger, located from various locations in the parking lot at 3101 West Princeton Street. May I approach, Judge?
Sure.
Those are the 8 casings that you matched to Lieutenant Clayton's gun, correct?
Yes.
Okay. And then the other casings that were collected from that scene were matched to the 40.
That's correct.
Thank you. Now, we were discussing before I jumped to the side about the process you used to identify the 6-hour to this projectile that was located on the other side of Walmart, correct?
That's the projectile we're speaking of. I'm not sure what it is in relation to the Walmart.
And that's the one you said was damaged and looks like it struck something, and that probably would have caused the damage?
Yes.
Okay. That's the one we're talking about.
Yes.
And the damage from that particular could have been caused by striking anything that's hard, correct?
Correct.
Including a wall.
Yes.
It's not unusual for bullets to ricochet off of walls.
It's not unusual. Anytime it strikes something, it's going to cause damage to the projectile.
Okay. Now, going back to your process of comparison, I think we were talking about the 4 HP pedals observed. That's one of the things that's consistent with ammunition that could have been fired out of the 6 Sauer, correct?
It could have been fired out of any pistol. A hollow point is a type of bullet loaded in any caliber cartridge.
But you directly eliminated the 2 other guns that we talked about, the 9mm Luger, which the shot was fired, the 1 shot and 1 casing at a different scene, and the .40. This particular piece of ammunition that was recovered, the projectile, did not come from either of those guns, correct?
Yes, that was based on the class characteristics of the rifling present on the projectile.
All right. Is it your testimony that the 4 hollow point petals observed are visually consistent or inconsistent with the 6 Sauer?
May I consult my notes?
Sure.
I said that they were consistent in appearance with the manufacturer Winchester, either Winchester PDX or SXT.
Okay. Which would be consistent being fired out of the 6 Sauer?
It would be consistent with that model of ammunition produced by Winchester.
Okay. And there were several little hints that while you were going through your worksheet and recording information, that I don't think lean is the right way, but indicated that this piece of ammunition could have been fired from the Q4 gun, which is the 6 Sauer.
I would say it was more that it was consistent in appearance with the cartridges that were recovered with the 6 Sauer pistol.
Okay, thank you. And the determination you made in regards to that you can't say it is, you can't say it isn't, that's based on the damage to the projectile, correct?
Yes.
Okay. If you had a projectile that wasn't damaged, it'd be much easier to tell.
It may be easier. I think it's also worth mentioning that when I test fired the 6 Sauer pistol, that I evaluated the individual characteristics on the bullets that were fired by that 6 Sauer and recovered by myself. I compared those under a microscope, and those were actually very difficult. I may not have been able to identify any bullet as having been fired from that 6 Sauer. It wasn't imparting sufficient individual characteristics to the bullets that were fired by it. So no matter the condition of a bullet recovered, I may not have been able to identify that to the 6 Sauer pistol.
And why is that?
It may be because the barrel is too smooth during that manufacturing process, or the continued use or abuse. The barrel has become so worn that it's not imparting a sufficient number of scratches for me to perform a conclusive comparison on projectiles fired from that gun.
Okay. But if you had all the casings that were ejected from that gun, you would be able to identify all of those in comparison to the 6 Sauer, correct?
I was able to identify all the cartridge cases as having been fired from the 6 Sauer.
So the 8, correct?
Yes.
But if there was another one, you'd be able to identify that as well?
If it were in good condition, it's possible.
Okay. Now, I'm going to have something marked because I know you're out of town, and so we normally introduce evidence in our case in chief, and I'm just going to show you a photograph. I think you took a bunch of photographs of the various projectiles and ask you to identify it. And we're not going to show it to the jury at this point, okay? All right, I'm showing you what's been marked as I for identification defense. Do you recognize that?
I do.
What is it?
They're the projectiles that I examined under this case, under FDLE case number 2017-0500-342, specifically submission 3.
Okay, and isn't it a fair and accurate depiction of those?
Of these projectiles, yes.
All right, thank you. I have no questions, Judge.
Thank you. Redirect.
Oh, hold on one second. Where am I going? He said that. Yeah. Yeah, he said both guns. Well, I have nothing further. Thank you.
Thank you. Redirect.
Yes, Your Honor. Mr. Ruth, I thought you were clear, but I'll ask you again. On direct examination, you testified that the Sig Sauer could very well have fired the projectile that was represented as found from the Walmart, the damaged projectile.
Yes.
Right. But you're certain that the projectiles represented as coming from the medical examiner, one for Debra Clayton, one for Sade Dixon, were fired by the .40 caliber firearm?
Yes.
That's all I have, Judge. Thank you.
May this witness be excused?
He is excused and released by the state of Florida. Yes.
Second, Judge.
All right, thank you, sir. You are free to go.
Thank you.
Let me see the attorneys up here for 1 second, please. Mr. Williams, call your next witness.
Your Honor, we have no more witnesses. We'd ask the court to admit States BS, a stipulation as a next numbered exhibit, and then it be read to the jurors.
Any objection?
No objection.
This will be admitted as State's Exhibit 61. Thank you. Ladies and gentlemen, this is a stipulation. The Assistant State Attorney, M. Ryan Williams, and Defendant Markeith Loyd, as well as the attorney for the defendant, Terrence Lenneman, stipulate to the following. On January 9th, 2017, Markeith Loyd had previously been convicted of a felony in the courts of this state. Further, on January 9th, 2017, Markeith Loyd had not been pardoned or had his civil rights and firearm authorization restored. Because the defense and the state have stipulated, these facts should be considered as true in your deliberations. All right, call your next witness.
Your Honor, at this time, the state of Florida rests.
All right, ladies and gentlemen, the state of Florida has rested. So here's what we're going to do. There are a number of legal issues I need to address. So your lunch is here, you're going to have lunch, then you're going to get the afternoon off to relax so that I can get all these legal issues addressed. And we will be back tomorrow morning to start the defense's case. So we will work tomorrow, we will work Saturday until 1 o'clock, You will be off on Sunday, and we will resume on Monday. All right? We are on track to finish the case as scheduled. All right? I'm not going to give you an exact date, because if we miss it, then you're going to tell me, but you told us. So, I'm like, yes, sir. I told you it was no more than 2 to 3 weeks. So, all right? Thank you all. Have a good lunch. I'll see you tomorrow morning. All right. I have been informed after further investigation by the Sheriff's Department, Juror 759 is the juror who asked the question about the gun belt, and she asked it of 3 different deputies, 2 of whom refused to answer, simply said, I don't know, the 3rd of whom said 30 pounds. That's all the information I have.
We're not ignoring you, Your Honor, we're just thinking. So,
Oh, no,
thank you.
I could hear both sides sort of thinking. State.
Your Honor, we would ask the court to bring the juror in and ask the reason why she was asking the question. And this is our logic, so you can follow. If the juror is just curious about gun belt weight, that's not an issue. If she's asking because she's wondering about evidence that's been presented in the trial, we don't know that that is an issue either, but she needs to be instructed that she can't do that any further. We don't believe that that goes to any thought process that she would have about the verdict, because she's not supposed to have a thought process about the verdict at this point. So that's our suggestion as to what to do specifically, but regardless of what questions are asked, we would ask that the juror have an inquiry made of her.
Defense. Mr. Waterman. I can't hear a word you're saying. You stand up and turn on your mic.
We have no questions for the juror, and I mean, it's really the court's discretion, but I'm not concerned about that question.
I need to think about what I'm going to do. It's sort of an unusual situation. And I don't think it's an emergency that can't be handled tomorrow morning when she comes back, and gives me some time to do a little bit of research. And I'm very leery of getting into jurors' thought processes, but I'm inclined right now at the very least to simply bring her in and explain to her that she can only base her verdict on testimony that she has heard in the courtroom, and that no additional information or facts can be used to reach a verdict, which is just re-instructing her on the standards. But I want to think a little bit about what I'm going to do, okay? All right, folks, we're back at 1:30 for the mutiny motion. Anything else that's scheduled this afternoon?
I think we're going to discuss instructions. Was that the plan?
Well, yeah, jury instructions. We'll go over the preliminarily, the jury instructions. So we're still on schedule to go to verdict on Tuesday?
Yes, Your Honor.
Okay.
Judge, when would you like to?
Can't hear you.
When would you like me to do my very short judgment of acquittal motion?
You can do it right now if you'd like.
All right, Judge. We'd renew all prior motions and objections, including the motion for a mistrial. We'd move for a judgment of acquittal in light most favorable to the state. We believe that they have not proved premeditation based on the evidence that they have presented, and we'd move for a judgment of acquittal based on that.
All right. As to the mistrial motion and all prior motions, the same rulings apply. State response to the JOA.
You know, the state's review of the elements of each of the offenses is that there is at least prima facie evidence to go to the jury on each of the elements, specifically as to premeditation. I know Your Honor is aware of the case law, that that's primarily a question of fact for the jurors to determine. We believe we've proved premeditation as to Lieutenant Clayton, if with nothing further than the Facebook posts, which are now record evidence.
All right. Court's been paying attention, keeping notes at this time as to all accounts. I do find that the state has established a prima facie case sufficient to go to the jury through the testimony of the various witnesses and the video and the exhibits that have been placed into evidence. So the motion for judgment acquittal is denied at this time. Well, since we're on tomorrow's, Mr. Loyd. Mr. Loyd, I need to talk to you for a moment. This is a preliminary discussion, and I'm not going to put you, I'm not going to have you affirm. We'll have this discussion again tomorrow. Mr. Loyd, you have the constitutional right to testify in this case if you wish. You also have the right to remain silent in this case. The only person who can make the decision as to whether or not you are going to testify is you. You certainly should consult your attorneys, but in the end, it's your personal decision as to whether you wish to testify or not. If you take the stand, you are waiving the right to remain silent, meaning the state can ask you any questions on cross-examination about this incident or anything that you opened the door to during your testimony. Your attorneys will explain to you what opening the door means, but it basically means if you testify to things that I have ruled inadmissible, they may become admissible by opening the door. Your prior convictions, the number of them, not the details of them, are admissible felony convictions and any conviction involving dishonesty. So I will be asking you tomorrow if it comes to the point where you're telling me we're at the point where he may or may not testify. I will be asking you more detailed questions about that, but I did want to make sure that you got the preliminary instruction for me about you testifying. All right. Anything else, folks?
No, Your Honor.
No? All right, we'll see you back at 1:30. Court's in recess. Thank you. There we go. All right. Back on the record on State versus Loyd. He's present with his attorneys. State Attorney's Office is present. This is the state's motion to use the federal conviction for mutiny
Yes, Your Honor.
as an aggravator prior violent felony.
Is my computer mirrored to yours up there, Your Honor?
It says, please wait for the host to start the
Okay.
meeting. So it says start 1:30.
Okay.
It's extremely, I use Zoom a lot. It's extremely picky about the start time. So let me turn the volume up. There you go.
Is that the courtroom audio that you just turned?
Yes.
Thank you.
I turned it up to max. All right, I'm ready when you are, other than the Zoom is not connected yet. But if you want to start without the Zoom, it's fine.
So are you asking for legal argument at this point? Because I
Oh, no.
have one witness, the defense has one witness.
Oh, that's fine, we can
Okay.
wait, no worries. I didn't know if you had something else to present prior
No, Your
to
Honor.
the Zoom
We
witness.
have a variety of exhibits that need to be limited to our commission. And I have no objection to, for purposes of this hearing, moving all these exhibits in.
Okay,
Defense, it's marked as J. You want to mark as J for purposes of this hearing? Yes. Okay.
all right, so J will be received without objection as Defense Exhibit Number 1 for purpose of this hearing only. Have you started the meeting? Have you opened the meeting?
I have.
Yeah, it's not.
He's waiting for the host, which I believe is the court reporter's office.
Oh, okay, all right.
She hosted the meeting?
Yeah, mine.
Okay, then we're going to have to use your computer then, because I don't have the ability to log in as a host. Oh, wait, maybe not. Nope. I apologize, Your Honor, I didn't realize that.
No problem. Do you all have a court reporter on that end to swear in these witnesses, or?
I don't believe so, Your Honor.
Hey, Eric, hold on a second.
I have a green screen. I have nothing. I have a green screen.
Doesn't have anything on the screen.
Let me get out and reconnect and see if that does it. Hold on.
Well, it's not, this is the same problem we had when we tried to do it before.
If you're in on your computer, can we just switch and use your computer?
I have a green screen.
Yeah, we're going to try to. Are you in?
Here, let me simplify this. Do any of you have, let me see if I have a Zoom
I
connection.
think we're going to be okay, Your Honor.
Do you guys have the meeting number and the password?
I do not even have all that. Yours should be mirrored now.
All right, let me try. Yeah. Yeah. Mr. Lemon, you have to mute your computer, mine. And the witness needs to turn their video on.
Eric, can you hear me?
Oh, yeah, I'm here.
Turn your video on for me.
Yeah, I can hear you fine.
Turn your video.
My video?
Yes.
I was seeing you a second ago. Let me see. Start video. Okay.
There you go.
Yeah, there you go.
Okay, I think we're good to go, Your Honor. Can you see and hear him?
I can. All right. Call your first witness.
The state calls Eric Stokes.
All right. The person who's appearing on the Zoom screen, does the state recognize him to be Eric Stokes?
Mr. Stokes, do you have an ID? I've spoken to him on the phone. I've not seen him in person.
All right. So I'm looking at his law enforcement officer ID. Sir, can you raise your right hand?
Eric, raise your right hand.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Can you hear me?
Can you hear the court?
No, let me I'm turning it up just a little bit. I'm sorry. Go ahead.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. You may inquire.
Thank you, Your Honor. Can you please state your name for me, sir?
My name is Earl Stokes.
Okay. Where do you work now?
USP Atwater, California.
And what is that?
What is it? It's a federal penitentiary.
How long have you worked there at Atwater?
Well, that did not go well. Mr. Lenneman, you're not allowed to touch your computer anymore. All right, take that away from him and reconnect, please.
You're the host, so if you shut down. Yes, because you're hosting it. You just ended the meeting. Okay.
We got disconnected for a second.
Okay. There you go.
Mr. Marrero, can you please?
Okay,
Yes.
Can you hear me?
Yeah, I can hear you.
Okay, great. Hold on one second.
There you go.
All right, I think we're good, Your Honor. I apologize.
No problem. Go ahead.
All right, Officer Stokes, how long have you worked at the U.S. Penitentiary in Atwater?
A little over 15 years.
And back in, let me direct your attention back to February 23rd of 2007. Were you working there at that time?
Yes.
What were your duties back in February of 2007?
I was a correctional officer.
As a corrections officer, did you have personal interactions with inmates on a regular basis?
Every day.
Did you work with another corrections officer named Officer Perfecto at that time?
Yes, I did.
And what were his duties?
Same. He was a correctional officer.
Did you work on in the same pod or same area of the prison as Officer Perfecto?
On that day, yes. He was adjacent to me. He was in the Bravo side.
Okay. Can you explain to the court how the sides of the pod that you and Officer Perfecto were situated?
So basically, it is considered a unit. There's an Alpha side and a Bravo side. They are connected by a small hallway, which are back then were secured. And at each side, there's approximately 120 inmates.
So how many corrections officers were assigned to each side of that pod?
Back then, it was one each.
Okay, so my understanding that you were in charge of one side of the pod and Officer Perfecto was in charge of the other side?
That's correct.
And each side had about 120 inmates?
That is correct.
Okay. You said there was a hallway between the two pods. Were inmates able to walk back and forth through that hallway between pods?
Not freely.
One more time?
Not freely.
Not freely, okay. Was there a separate door that went into each of the pods
Yes, there are 3 entries to each unit, or at each side of the unit. That side has a counselor door that is the connecting hallway that you can enter the unit. There's a secure corridor that you can enter the unit, and then there's a compound side that you can enter the unit. And that's the same for each adjacent unit, A side and B side.
Did each officer have a physical key that was used to open the doors?
Yes, they have the ability to go out any of those 3. However, in those days, we didn't have the ability to meet up together with the same keys and fear that if there was a riot, they could take over the whole unit, the A and the B side.
Okay, so am I correct that if you had your own key that gave access to, say, pod B, you couldn't use that same key to get into pod A?
That is correct.
And vice versa, obviously?
Yes.
Okay. At some point on February 23rd of 2007, did you receive word that Officer Perfecto needed some help?
Objection.
Yes. There's a thing that's
Hold on, officer.
Mm-hmm.
Okay. There was an objection, then you need to stop. At some point, did you get word or receive information that Officer Perfecto needed help?
Yes.
And how did that information get to you?
It is disseminated via radio from control. The radios have the ability to what is called a hot mic, and then control will notify what they hear to the rest of the institution for responding staff.
And what do you mean by a hot mic?
It's called a body alarm. It's a button that's located on top of the radios that can be initiated when something's going bad by the officer.
So an officer sees a situation, that officer can activate the body mic, which then control will hear?
Yes.
And then control can disseminate that information to the necessary people?
Yes.
Right. Once you heard that Officer Perfecto needed help, what did you do?
I tried to respond. However, all I could do was look through a window.
Okay, describe where you were when you first heard that Officer Perfecto needed assistance.
I was on the adjacent side, and when I came through that corridor or that small hallway that I described earlier, I came up to his door, which I did not have keys back then to access, and I had to observe pretty much what was going on.
And when you got to that door looking into the pod that Officer Perfecto was in charge of, what did you see?
I seen an inmate picking up and slamming him.
Okay.
Multiple times.
Objection.
Hold on.
This is irrelevant, Judge, because if you follow the case law in Florida, they cannot bring in things that were uncharged. There was a negotiation from an assault on a corrections officer down to mutiny, which is considered, when you hear from my witness, a nonviolent crime. So all of this is irrelevant. The courts make very clear this cannot be brought to a jury.
Respond.
Your Honor, in order to make that legal decision, I think the court needs the testimony as to the facts based on all the case law cited in my motion.
Right now, I think that's I think your objection is at the end, not right now. I don't know what happened, so I need to hear what happened, and then I'll make a decision as to what was relevant and what isn't. So, go ahead, you can answer the question.
Okay. So Officer Stokes, what did you see when you got to the door that led into Officer Perfecto's pod?
That he was being picked up and slammed to the concrete multiple times.
About how far away would you have been from this?
Maybe 40 to 50 feet.
And are you able to see this through the closed pod door?
Yes.
Okay. how were Officer Perfecto and the inmate positioned when you first saw the two of them?
The inmate, I could see his right side, and the officer was on the ground after that was done.
Okay. Did you see how the officer got to the ground initially?
After seeing him being slammed to the ground.
Okay. So am I correct that when you first saw these two individuals, were they standing or was one on the ground already?
One was standing.
One was standing?
Yeah, it was the inmate was standing.
Okay, and when you first saw them, Officer Perfecto was already on the ground?
Yes. Well, no, not when I first saw them. When I first saw them, he had been picking him up and then he had slammed him.
Understood. Okay. After Officer Perfecto was slammed to the ground by this inmate, what did you see happen then?
All I seen was him just like he was helpless.
Okay. Was it only one time that Officer Perfecto was slammed to the ground, or were there multiple times?
No, it was 2 to 3 times.
Okay. Were there any other inmates in the immediate area when this was going on?
Yes.
Okay. Did this happen in like a common room area where inmates were able to frequent?
It's called the flats. It's where they all can basically hang out, watch TV, sit, play games, whatever. So everybody was in the unit at that point.
When you saw this happening, what did you do?
I started kneeing and slamming the door to try to distract as much as I could because I was helpless. I couldn't really get in there.
And what happened when you started kneeing and kicking the door?
They stopped for a moment, and at that time, Officer Perfecto got up and ran to the door.
What did the inmate do?
Just kind of paused and was yelling.
Once Officer Perfecto got to the door, what happened?
He opened the door, and I pulled him in, and I just said, stay, and I took off running into the unit.
And when you ran into the unit, what happened?
Other officers were responding from the adjacent door from the compound, and we ground.
And you did what? I'm sorry?
We placed the inmate on the ground and restrained him with restraints.
So was the inmate eventually subdued and I'm assuming taken away to a different location?
Yeah. We take them to the lieutenant's office and then through medical to be assessed.
And what was the name of the inmate involved in this?
This was inmate Markeith Loyd.
Okay. Now, after this incident, I'm assuming there was some documentation that had to be done to document the incident, right?
Yes.
Did you?
Go
ahead.
No, I'm sorry. Go ahead.
Did you write any kind of a memorandum or a statement?
Yeah, the best that I could.
And have you seen that memo?
Just recently.
Did you, after reviewing that memo, did you include a great deal of details about what you saw before you personally became involved?
Not all details.
Why not?
I was still a rookie, and I had not even went to schooling yet in Glencoe, Georgia yet.
Okay. So you didn't include that amount of detail?
I didn't have the proper training for the layout to do the memorandums. I just did the best that I could at the time.
Okay. Any doubt in your mind that you saw inmate Markeith Loyd grab Officer Perfecto and take him down to the ground?
100%.
Okay. No further questions at this time, Your Honor.
Officer, are you still an officer?
Yes, sir.
Okay.
Oh, an officer.
You first testified he was taken down and picked up a second time. And then at some point when he was asking you about what happened, you said the first time you saw him, he was on the floor. Isn't that correct?
The first time he was in motion to the floor. He went to the floor, yes.
So is it your testimony that you never said the first time you saw him, he was on the floor?
What I seen was him being slammed to the floor.
And you actually put in your report, which was dated to February 23rd, 2007, to Lieutenant White, that you observed inmate Markeith Loyd standing over Officer Perfecto from 2B's team door Officer Perfecto stood up and came to the team door and entered while the responding staff entered from the compound Sally door. Isn't that what you put in your report?
That's partially correct. What I stated was that myself and the responding staff came into the unit, and at that point, he did stand up and come to me. That's after I had made an attempt to distract him by kneeing the door and slamming on the door.
Well, let me read your entire report. On February 23rd, 2007, at approximately 7:30 p.m., I responded to 2B's body alarm from 2A. I observed inmate Markeith Loyd, 23539-018, standing over Officer Perfecto from 2B's team door. Officer Perfecto stood up and came to the team door and entered while the responding staff entered from the compound Sally Port door. I then entered the unit of 2B. Inmate Markeith was yelling, "It's not a war on drugs, it's a war on us. They are coming for us." Inmate Markeith came towards me, and Officer Almana, Lieutenant White, and I gained control of the inmate by placing the inmate on the ground. I applied the handcuffs while Officer Almaza applied the leg restraints. The inmate was removed from the unit by responding staff, and there is nothing further to report on this incident. That was your report that you wrote, right?
That is correct.
Now, you were a corrections officer back then, right?
I was a correctional officer for a few months.
And so, as a matter of fact, you were trained before you became a correction officer how important it was to prepare reports. Isn't that right?
No, that is not correct. I had not been to Kalenko. I was never an officer prior to becoming a correctional officer.
And so, when this ended up getting charged, were you ever told that Officer Perfecto didn't want anything to do with this? Did he ever tell you that?
No, not at all.
Judge, the only thing is I'd move in his report as evidence for the court to consider. No, that wasn't part of it, but I want to.
Just to write in the record, I have no objection to the statement with the statement coming in.
All right,
For the purpose of this hearing only.
then that'll be admitted as defense exhibit number 2 for the purpose of this hearing only.
I have nothing further of this witness.
All right, redirect.
No redirect, Your Honor.
May this witness be excused?
Yes, Your Honor.
All right, thank you, sir. You are free to go.
Thank you, Officer Stokes. You can sign off, and I believe there's another witness, Eric Hurston, who's for the defense.
Yes.
Does anyone have a statement?
I do. I just have to be able to.
I can give you my copy, Your Honor.
Okay.
Can I see? Oh, sorry. Thanks. Thank you.
All right. So for the record, the statement is now been handed over. All right, so you have no further witnesses, Mr. Proctor?
I have no other witnesses for
All right. Call your first witness, Mr. Williams.
Eric Hurston, Judge, can I get him big on the screen? How do you do that? Okay.
When he speaks, he'll pop up. Mr. Hurston, can you hear me? Mr. Hurston, can you hear me? Have you guys unmuted everyone? Because I'm not the host, so you have to unmute others for them to be able to be heard.
You need to unmute. Can you hear me, Mr. Hurston?
Yes, I can hear fine.
Okay.
And you unmuted me.
You are not, I don't believe you're a member of the meeting because it's being broadcast through this computer around here.
I don't know that he can hear me. Can you hear me, sir? Let me try this. Hold on.
Just probably just picked up the microphone on the laptop.
Let me do this. Did our laptops turn off for obvious reasons? Sir, can you hear me? Sir, can you hear me? This is Judge Marquez. Can you hear me? He can't hear a word I'm
Mr.
saying.
Kirsten, can you hear the judge?
I faintly heard a woman in the background. I'm not sure whether that was the judge or part of the court staff.
That was the judge.
I'm not hearing the judge right now.
All right. Do you all recognize him as Mr. Kirsten, or does he need to show me ID? Do you?
No. I'm fine, Your Honor.
Okay.
I've not met him, but I...
All right, sir, I need you to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may inquire.
Would you tell me your name, sir?
Eric Kirsten.
And how are you currently employed?
I'm an assistant federal public defender in the Eastern District of California, in Fresno, California.
And how long have you been doing that?
23 years.
Did there come an occasion where you represented Markeith Loyd on a criminal charge?
Yes.
Can you tell me approximately when that was?
I believe it was approximately 2008. I believe the case was filed in 2007 and it was closed in 2009. Another attorney from our office actually handled Mr. Loyd's case for nearly a year. But eventually I took over after approximately 11 months.
Okay. And what was he charged with at that time when you took over?
He was initially charged with assault on a correctional officer.
Okay. Now, we entered several documents into evidence for consideration by the judge, which includes two plea meetings, a sentencing, and I think there's one other document. Were you present during all those events?
The plea meetings and the sentencing, I was certainly present. I'm not sure what the other document you're referring to was, so I can't say for sure regarding that matter.
Okay, so let's go through your involvement in this case. When you became involved, did there come an occasion when the discussion of plea came up with the Assistant U.S. Attorney?
Yes.
And tell me about that.
Well, by the time I got involved in the case, most of the preliminary work had been done by Ann Voris of our office, who she has since married. Her name is now Ann McGlennon, and she's retired from the office. She's in private practice as a panel attorney. But she had done most of the preliminary work. When I came on board, it was really a point of trying to figure out a plea agreement that could resolve the case. I think there was a general feeling amongst everyone involved, including the prosecutor, that the amount of time Mr. Loyd was facing was excessive based on his conduct in the case.
Okay, and tell me what was the concern in regards to career criminal?
They have sentencing guidelines in federal court for each offense. There's a base offense level. Depending on the circumstances around the case, that base offense level is either increased or decreased. And that's on one axis of a chart from 0 to 43. From 0 to 6 on the other axis is a career history, a criminal history. Each time a person gets in trouble, they receive points based on the total number of points. They're placed in a career history, criminal history category. Where those two columns intersect, there's a recommended sentence in terms of months. That sentence is advisory. It's not mandatory on the court, but it's a starting point. And as a practical matter, it's the most likely place the sentence is going to end up. Because the maximum possible sentence was 8 years in Mr. Loyd's case, if he would have been deemed a career criminal, he would have been facing an advisory sentencing guideline range of 36 to 47 months. Which actually isn't all that long for a federal case, but we felt it was excessive for the facts. And if we were going to go to, if that's what the sentence is going to be, I think we certainly would have gone to trial in the matter. We were hoping to get something with a lesser sentence. Ms. Voris had attempted to negotiate a misdemeanor out of the case, and the government wasn't willing to do that. So when I came on the case, my primary focus was finding some sort of alternate charge that could be pled to that would result in a lesser sentence, and that's how that's how the mutiny charge came up, which is, it sort of sticks out in my mind because I've been doing this for a long time, and that's the only time I've ever come across that. I've never seen that charged in any other instance. It's an unusual charge, I would say.
And I asked you, I think we had a conversation, an email last night about whether you knew of any jury instructions that were ever created for that particular statute?
Yeah.
And your response was?
Yeah, there are no Ninth Circuit pattern jury instructions for that offense. I believe I emailed you the elements that needed to be proved for a conviction according to the plea agreement, and I've got that plea agreement handy if the court would like me to refer to it.
So let's talk about the plea agreements. Tell me, well, before we get to the plea agreements, was it an interaction between you and the prosecutor to try to find a case that wouldn't place him in a career criminal exposure?
Yes, because the focus was on trying to get a lesser sentence. We thought the case should resolve, and I know that I practiced as a defense attorney in state court in Arizona before coming over to the federal system. And I know in state court there were a multitude of charges, and there was a lot of flexibility, and we could usually determine what we thought was a reasonable resolution and enter a plea agreement fairly easily. In federal court, there are fewer charges. There are fewer offenses that are set forth. And normally, at least here, and I imagine in most locations, the government's position is they want a sentence within the sentencing guidelines in most circumstances. And so it was trying to find some sort of an offense that would result in a lesser sentence that Mr. Loyd would agree to.
Okay. And did you find that?
Yes, I did.
And what was that?
It was inciting a mutiny. I believe it's 18 United States Code, Section 1792.
Now, there was a little confusion when I was looking through the documents because some of the documents say attempted and some just say inciting a mutiny. Which was it?
I believe it says attempting to incite a mutiny. Frankly, I don't have the statute in front of me, and I'm not sure exactly, but I believe that that's what he pled to. But in the federal system, whether it's an attempt or whether it's a completed act, the sentence would be the same.
Okay.
And here, I think I was going to say, because there was no mutiny, we probably went with the attempt to incite a mutiny.
Now, was there mental health issues that contributed to the decision to reduce the sentence?
Indirectly. I don't think that the government made its plea offer to avoid some sort of a mental health defect.
Hold on 1 second.
But based on the video of the...
Hold on.
Hold on.
What?
Okay.
My objection is relevant for purposes of this hearing.
I can't hear what's being said right now. I can hear noise in the background, but I can't make it out.
My objection is relevance. Whether there's an affirmative defense or mitigation of mental health issues is not relevant to whether this event is admissible as a prior violent felony.
Sustained.
All right. So tell me what the elements of the mutiny charge that Mr. Loyd pled out to and where they are located.
Okay. They're located in the... here. I've got a copy of the plea agreement that was entered into in Mr. Loyd's case in the Eastern District of California.
Okay, could you like note so we see, or maybe place the page up to the thing so we can see what it says? There you go. It says Memorandum of Plea Agreement pursuant to Rule 11E. Okay, that was introduced, Your Honor. Go ahead.
Can I have
And
let me have the packet, please.
on page 2 of the plea agreement.
He can keep talking.
Oh, okay. On page 2, go ahead.
Yes, under the nature, elements, and possible defenses section at line 16, it says the government, in order to secure a conviction, the government would be required to prove the following elements beyond a reasonable doubt. First, the defendant attempted to cause a mutiny. Second, the mutiny the defendant attempted to cause would have occurred on the grounds of a federal penal institution. Third, the defendant intended to cause a mutiny. Fourth, the defendant did something which was a substantial step towards causing a mutiny. Mere preparation is not a substantial step towards the crime of causing a mutiny. A mutiny occurs when inmates acting together resist a prison warden or his subordinate officers in the free and lawful exercise of their legal authority.
Okay.
And there was also sort of a bare bones factual basis, which Mr. Loyd agreed to in the plea agreement as well.
Could you read that?
And that was on page 5 of the plea agreement. And the factual basis states, on or about February 23rd, 2007, within the Atwater Federal Penitentiary and in the County of Merced, State and Eastern District of California, defendant Markeith Loyd intentionally attempted to cause a mutiny in a federal penal institution. Defendant Loyd deliberately and intentionally exhorted his fellow inmates to resist the directives of penitentiary staff members who were properly and lawfully exercising their legal authority.
Okay. And that was the complete factual narrative that was agreed to?
Yes.
Okay. When we talked, we went through a couple of things prior to you giving me a deposition with the prosecutor. And those things were things that were important to you in regards to this particular plea. Can you tell me those?
I'm not sure specifically what you're referring to, but I know that the main focus in reaching a plea agreement was to get to a sentence that we believed was commensurate with the acts by Mr. Loyd. The guideline sentencing range for this offense was 15 months. The government was in agreement with the recommendation towards a sentence of 15 months. That wouldn't be binding on the court, but still it's a recommendation by the government. And that was the primary focus. The reason for that is that, based on my view of the video of the incident, and I can't speak for the government, but I believe that was their motivation as well. There was no apparent intent by Mr. Loyd to injure the correctional officer in the assault. I believe if there had been an intent to injure the correctional officer, the government believed that happened. There's no way they would have agreed to this plea agreement.
Okay. I have no further questions, Judge.
Cross?
Good afternoon, Mr. Kirsten.
Good afternoon.
If you can't see me, this is Rich Buston with the State Attorney's Office.
Okay.
So the record's clear. The individual that we're talking about that you represented is Markeith Loyd, correct?
Correct.
Date of birth 10/8/75?
I don't know his date of birth, but that seems accurate.
Okay, and it occurred at the federal penitentiary in Atwater, California?
Yes.
Okay, you mentioned in your direct examination that there was a video associated with this event?
Yes. Yes.
And you have a memory of that video, correct?
Yes, I do.
You don't have that video anymore in your file, right?
No, it's been misplaced. I looked for it and couldn't find it.
Okay. And I believe last we talked during your deposition, you were going to put a request in to have some other people look in like a storage facility.
I was in conversations with the branch supervisor of the United States Attorney's Office here in Fresno.
Has there been any success as of today in finding that video?
Actually, I received Kirk Sheriff is the assistant U.S. attorney I was communicating with. I received an email from him last night that they had received the file. They found some video in discovery, but they were having a hard time opening it. I received a message from him that he was going to see if their IT person could open it up because they were having problems.
Okay.
But that's all I know. I haven't heard back since then.
Okay, I appreciate you taking the efforts to follow up on it. You don't have any notes from your viewing of that video in your file either, correct?
Correct.
Okay. Based on your memory of the video, am I correct that it showed the defendant, Markeith Loyd, clearly grabbing Officer Perfecto by the shirt or shoulder area?
Yes, I can't remember exactly how they came together, but my recollection is that Mr. Loyd sort of grabbed his shirt and shoulder and stepped behind Officer Perfecto and sort of pulled him down to the ground.
Okay. So Mr. Inmate Loyd grabbed Officer Perfecto and brought him down to the ground?
Yes.
Okay. And based on your memory of the video, after Officer Perfecto was on the ground, it showed the defendant grabbing Officer Perfecto's feet and spinning him around a little bit, right?
Correct.
Okay. So even by your memory of the video, would you agree that the facts as you remember them show that the defendant made contact with Officer Perfecto's body?
Yes.
And that contact was obviously not friendly?
I'm sure it wasn't friendly from Officer Perfecto's perspective. I don't think there was any intent to harm Officer Perfecto, just to pull him to the ground and create a disturbance.
Okay. Based on that conduct, Inmate Loyd was arrested originally for assaulting a federal corrections officer, correct?
Correct.
And by your analysis of the case and facts, would you agree that the facts would have supported the felony crime of assault on a corrections officer?
Probably yes, because the only physical contact is all that was required. Part of the difficulty in the case was that the indictment actually charged assault by striking or beating, I believe. And there's no way that would have stood, but I believe there was physical contact, and Mr. Loyd pulled the correctional officer to the ground, so I believe that the assault charge would have stood for that reason.
You cut out. Do you believe the assault charge was what?
I believe the assault charge could have been proved for that reason.
Okay. And the crime to which the defendant pled, the instigating a mutiny, is a felony charge, correct?
Correct.
Okay. And in this case, a pre-sentence investigation was done on the case, correct?
Correct.
Have you reviewed that pre-sentence investigation? I believe it was prepared by a federal probation officer on April 3rd of 2009.
I haven't reviewed it since the case was closed. I believe that I mentioned in the deposition. I believe that report was in the same section of the file that contained the video, and so I haven't reviewed it recently.
Okay. The sentencing on this case occurred April 10th of 2009, correct?
I believe so, yes.
And the pre-sentence investigation would have obviously been prepared prior to that sentencing date?
Correct.
And as a federal public defender, you would have reviewed at the time the pre-sentence investigation before sentencing, correct?
Correct.
Okay. Do you have any independent memory of the pre-sentence investigation facts that were contained in there?
No. No, I do not.
Have you reviewed the sentencing transcripts?
Not recently.
Okay. If you had an objection with the facts as relayed in the pre-sentence investigation, would the sentencing have been the time to make a challenge to those facts?
My focus of sentencing, well, yes. If I felt it was relevant to the sentencing proceeding, that's when I would have made the objection.
And in this case, you did not make any objection to the facts contained in the PSI because it wasn't relevant, because you had a sentence, an agreed upon plea to a lesser charge and a sentence already agreed upon, right?
Well, that's partly right. There was an agreed upon recommended sentence by myself and the prosecutor, and I assumed that the probation office was also recommending that same sentence, just because I didn't file a sentencing memorandum. If there had been a dispute regarding the appropriate sentence from the probation officer, I certainly would have filed a sentencing memorandum setting forth why I believe the agreed upon sentence was appropriate. Since I didn't file a sentencing memorandum, I feel quite confident that there was a recommendation from the probation office for the 15-month sentence.
And if there was a dispute as to the facts in the PSI, that dispute would have been reflected in a sentencing memo that you would have filed.
If I would have filed a sentencing memo and there were disputed facts, yeah, I would have definitely addressed them in the sentencing memo.
Okay, I think that was a bad question on my part. Would the sentencing memorandum be the proper vehicle to bring an objection to the facts in the PSI to the judge's attention?
Yes.
Okay. And at the time of the sentencing, would you agree that there was no objection to the facts as laid out in the pre-sentence investigation by you to the court?
Yes, I didn't file any formal objections, so that there wouldn't have been any objections to the facts by me.
And there was no objection made by the defendant, Markeith Loyd, at the time of sentencing to the court about the facts contained in the PSI, correct?
Correct.
Okay. Maybe one moment, Your Honor.
Yes.
I don't have any further questions for you, Mr. Kirsten. Thank you so much.
Redirect.
Yeah. Mr. Kirsten, can you tell the judge what a PSI is?
It's a pre-sentence investigation report prepared by the probation office. In the federal courts, the probation office they work for the court. They're supposed to do an independent evaluation of a case and make a sentencing recommendation. If there is an agreement in a plea agreement, the probation office is not bound by that agreement. They make their own recommendation as to what they believe the appropriate sentence should be. They also include facts about the case that they take from discovery, and also personal history about the defendant, sort of his background, his criminal history, a wide range of personal background information.
Do the probation office who does the PSI, do they participate in the plea agreement where a factual narrative is created?
No.
And you said if they have an objection to the factual narrative of the plea, that they would state that in the pre-sentence report.
They make their own, they don't make an objection per se. They just give their perspective on what occurred in a case.
So they're go ahead, I'm sorry.
Yeah, they're independent of the plea negotiations.
And you said they get that information from discovery. That would be documents within the court system.
Pardon?
You said they get the information in the PSI from discovery. Is that right?
Yes, that's correct. Normally, I think the government provides a copy of their file to the probation office.
Okay. And in this particular case, were you confident between the between the plea agreement and the communications with the prosecutor and the judge that this plea was going to happen the way it was agreed upon?
I was confident. In the federal system, judges don't participate in the plea negotiations. They're sort of independent. But since myself and the government and presumably the probation office, I haven't reviewed the report as I said, but since I didn't file any objections, I presume that the probation office was also recommending a 15-month sentence. And since everybody was on the same page as far as an appropriate sentence, I felt it highly unlikely that the judge wouldn't go along with it.
Okay. And so we're clear, the purpose of filing an objection is when your client is put in peril in some way that could affect the sentencing, correct?
Yes, if there was a recommendation for a more severe sentence, I would definitely address the factual disagreements.
And it's only necessary if you think that it's going to impact your client's sentence.
As a practical matter, yes. Whenever, if you want to make objections, that's where you make the objections. But if you're facing a sentencing where you're very confident that the sentence is going to be what's anticipated, it's not uncommon not to file a sentencing memorandum. I would guess in the majority of my cases, I'd file a sentencing memorandum, the large majority. And technically, a sentencing memorandum is more social background characteristic type information that would support a lesser sentence. Formal objections would be to the guideline calculations or the factual information. And again, I don't remember what factual information was contained in the pre-sentence report, but I know that the recommendation was for 15 months, and that's what my focus was on.
Okay. Those are all the questions I have, Judge.
May this witness be excused?
Yes.
All right, thank you, sir. You're free to go.
Thank you.
All right, argument, Mr. Buxman.
Your Honor, I will rely primarily on my motion that I filed regarding this issue. I think the Florida Supreme Court has made it clear that the court is to look at the underlying facts of the prior violent felony and not look at the name of the charge. I've cited to you a variety of cases in my motion, including Johnson v. State, 465 Southern 2nd, Gore, 706 Southern 2nd, 1328, a variety of other cases that throughout my motion. One other case I would point out, Reynolds v. State, 934 Southern 2nd, 1128, actually affirmed the trial court's decision to allow the state to introduce details surrounding a prior violent felony conviction, which also included facts that established he committed crime and was convicted. My point of citing all these cases is, again, the court is to look to the facts surrounding the prior violent felony, not the name. Though the defendant arranged and negotiated through his lawyer to get a plea to a lower crime, is that crime that he pled is still a felony, which is obviously the first predicate to admit a prior violent felony in a death.
Let me get clarification from both of you on something. Did he plead to attempted mutiny? Well, actually, was he convicted of attempted mutiny or mutiny? Okay.
If I could have one moment, Your Honor, I'll look at the actual certified copy of the conviction. It says 18 U.S.C. 1792, instigating a mutiny. That's the certified copy of conviction, which was included in the...
Okay, and then because that and the transcript of the plea are slightly, the plea seems to be to an attempted mutiny, but the adjudication, I can figure that out in a minute. Go ahead. Thanks.
I agree. The memorandum indicates a plea to attempt. The certified indicates a plea to instigating a mutiny. I believe the federal public defender indicated that in the federal system it doesn't matter because it's the same punishment and same code, I believe.
Okay.
And for purposes of my argument, it doesn't make a difference whether it's an attempt or a completed crime, because again, the court is to look at the facts of the crime itself. I believe in one of the cases I cited, the defendant pled to a lesser offense of attempted sexual battery, and the state later, in a death penalty case, attempted to use that as a prior violent felony. The court said it didn't make a difference as to whether it was an attempt. You look at the underlying facts. So here, the underlying facts in this case are, based on the testimony of Officer Stokes, he observed the defendant pick up Officer Perfecto on at least 2 occasions and slam him to the floor. Even if you disregard Officer Stokes' recognition of what he saw, based on the memory of Assistant Public Defender, Mr. Kirsten, who just testified. Mr. Kirsten said that according to the video he watched in his memory, Mr. Loyd grabbed Officer Perfecto by the upper part of his body area, went behind him and pulled Officer Perfecto to the ground. He acknowledged that the acts that he saw and the facts that he analyzed as his public defender would have constituted the crime of assault of a corrections officer, because that only required evidence of an unwanted physical touching. So even in the light most favorable to the defense as far as what happened, we have a crime of violence. Based on the case law I have cited to the court, the fact that it is a crime of violence under anyone's explanation, even the federal public defender's explanation, it should be admissible as a prior violent felony.
So you're seeking to admit you're just saying the facts of the mutiny, attempted mutiny, whatever it's called, are the underlying facts are the violence?
Correct.
Okay. Response?
Judge, they spin a web that is legally incorrect. In Mann, provide the court a copy of it, they make it clear they look to the underlying conviction and the record. The record is not what this officer, who I submit perjured himself about, where he wrote in his report one time being slammed down, as he said, versus 3 times. If you look on the page 2, Judge.
Terry, what do you have? What do you
Two of
Oh, I'm
what?
sorry.
Page 2 of Mann?
Yeah, page 2 of Mann.
I'm sorry, Your Honor.
If you look on the right-hand side, it talks about the prior violent felony, beginning at 581, going down to the end of the sentence. We are not presented with a copy of the Mississippi charge document and thus cannot determine whether alleged and the jury convicted him of breaking with intent to commit a crime of violence. The record of Mann's conviction, as presented to this court, does not disclose a conviction of a crime of violence. We hold that a prior conviction of a felony involving violence must be limited to one in which the judgment of conviction discloses that it is violent. In this particular case, you can argue that mutiny on its face could be a sit-down directed by Mr. Loyd, or a non-violent activity directed by Mr. Loyd. The courts do not allow the reach back from a charge that is not even designated as a violent charge, and there's no evidence that presents it was a violent charge, Judge. Although the public defender said he thought, yeah, it may be violent, but on its face, it's not violent. And so because of that, Judge, you cannot use this charge as a prior violent felony aggravator.
So there's a case. It's called, let me take this off so make sure you guys can hear me. It's Sweet versus Moore. Sweet is S-W-E-E-T. Moore, M-O-O-R-E. It's 822 Southern 2nd, 1269, Florida Supreme Court, 2002.
What was the last 828? Sorry.
822 Southern 2nd, 1269.
Thank you.
Florida Supreme Court, 2002. And this is what I'm going to ask both sides to address, but since you're up here, you go first, Mr. Lenneman. If you look at footnote 2 of the opinion, the court in this one specifically found prior violent felony aggravator using riot. And the Supreme Court affirmed. They don't actually, it's in the footnote is where you find it. And they found that a riot constituted a prior violent felony. So.
But there's no evidence of a violent before the court.
Hold on. Let me finish.
Thank you.
The federal statute says mutiny or riot. So a mutiny, I mean, I know that you say that a mutiny is not on its face violent, but a mutiny is also not on its face nonviolent. A mutiny can be quite violent. So I'm not sure why the fact that the word mutiny is being used would automatically preclude this from being considered a violent felony offense. I get the case you're citing to me. Burglary is not a violent offense. And if you go to trial and you're convicted of burglary but not of the sexual battery, you've been acquitted of that. So that would never be an aggravator. So I understand the case you cited, the man case.
It was burglary with a commission of violence. That was the charge.
Right, but he was
and
acquitted.
And the court said there was nothing on its face or anywhere that put this particular event in the box that would create a prior violent felony.
Mutiny, what is the basis of your argument that there is nothing about a mutiny charge that could be considered on its face to be violent? That's the question I'm asking you. No. Go ahead.
Well, first of all, Judge, I think that the situation needs to be looked at on multiple levels. Okay. Prosecutors trying to throw out this testimony from this guard that was inaccurate.
Forget the guard. Okay. Just base it on what your witness said.
Okay.
Which was that
so my witness says that when the prosecutor and the U.S. attorney and the defense attorney got together, right, they both agreed that this was an overcharge. An overcharge based on the event. He told you... Overcharge based on the sentence. He did not say it was an overcharge based on the event. He specifically said that Mr. Loyd could have been convicted of the original charge of assaulting a law enforcement officer or a corrections officer. So it was an overcharge based on the sentence he was facing. Okay. But nevertheless, Judge, it was agreed upon by the parties that they would reduce this to a charge to avoid a career criminal, which considers it to be violent. So when he was pleading this charge under the sentencing guidelines, he wasn't facing a career criminal possibility. Okay. And so they created this mutiny charge just out of the air to allow him to plead to this. And as you heard, at some point they were even talking about a misdemeanor charge that the U.S. attorney wouldn't originally would not agree to. So what we're talking about here, though, is what is the court allowed to do? Are you saying you're allowed to go, you know what, picking him up and throwing him down is considered mutiny? No. Considered a riot? No. There's no evidence of mutiny or riot here, Judge, at all in the record. The only evidence there is of the picking up and throwing down 3 times and then him being taken into custody. And the court has to look at the scenario to be able to make that decision. A mutiny, this is from the plea thing, it's been a long day, I can't talk. This is from page 2 of the plea agreement, the memorandum of plea agreement, where it says, a mutiny occurs, that's what it says, occurs when inmates acting together resist a prison warden or his subordinate officers in the free and lawful exercise of their legal authority. So would not slamming an officer to the ground constitute a mutiny? Absolutely not. Absolutely not. Because what? Do you have some law that says that? Or that's just your opinion, Mr. Loyd? It's no talking. Listen. Mr. Loyd, we are not listening to you right now. Go ahead. Judge, if I can see that document, because I don't have mine. Oh, this is what you filed. Yeah. It's the first orange tab. Okay. Don't write on this. This is the actual exhibit. I just tabbed it so I could get to it. If you need a minute, I'll give you one. Judge, none of these elements on second, third, and fourth have occurred or were proved up. Second, the mutiny the defendant attempted to cause would have occurred on the grounds of a federal penal institution, which is true. The defendant intended to cause a mutiny. There is an intent element. There's no evidence that he intended to cause.
That's what he pled to.
No, I understand that, Judge.
So I can't use now you appear to be arguing to me that the court cannot use the facts of what occurred that led to the plea, and I also can't use the actual plea agreement?
No, what you can't use, Judge, is the facts that they put forward to determine whether a mutiny occurs when inmates acting together. There was no inmates. There was one person, Markeith Loyd, acting together, resist a prison warden or his subordinate officers in the free and lawful exercise of their legal authority. There's no evidence that there were inmates acting together. And more important, that particular sentence can be filled with multiple nonviolent presentations. Sitting in, refusing to eat, refusing to get up.
And none of those facts were present here. What was present was him, I mean, even your witness doesn't deny that he put his hands on a law enforcement officer and took him to the ground.
But at the end, Judge, my client ended up pleading to something lesser, and you cannot use the facts from that to throw them into a mutiny. There is no factual support.
He pled to a mutiny.
No. What I'm saying is you're using the violent act.
Right.
They discounted the violent act, Judge. They didn't say that that was part of it. It was never part of the proffer. It was never part of the plea agreement. It was never part of the sentencing. There was no discussion about you picking up and throwing down this person, this guard, in any manner. None of that was used. You're trying to backdoor this event by saying, you know what, I think this is good enough to call it a mutiny. And, even though it doesn't involve,
They can call it one call, not back.
Inmates acting together, I'm going to just say that it fits the bill, and it doesn't, Judge.
Yes.
I mean, there's no question what it
Any other
said.
argument from you?
I'm sorry?
Any other argument?
Yeah, Mr. Loyd wants me to.
No, I'm not. Mr. Loyd is not a lawyer, so
Okay.
I'm just listening to lawyers this afternoon. Mr. Buxman, explain to me why the facts to which he pled, and they're contained in the plea. Let me have that plea agreement back, Mr. Lenneman.
Oh, I'm sorry, Judge.
Thanks.
I was walking out the door with it.
Yeah, that's why I'm taking back my exhibit. Mr. Buxman, the facts that he pled to here, or the facts that are in the plea agreement, don't contain any of the facts that you're trying to get into evidence. Or you're trying, let me rephrase that. You're trying to use to make this a prior violent felony aggravator. So why do you get to use facts that weren't pled to?
Because that's what the Florida Supreme Court has indicated. In Johnson v. State, you addressed the burglary issue before. Johnson v. State, 465 Southern 2nd, 499, Florida Supreme Court, 1985, which came out after the Mann case provided to you by the defense. In that case, the defense complained to the trial court instructing the jury that a burglary constituted a felony involving the use or threat of violence to a person pursuant to the prior violent felony aggravator. Florida Supreme Court said simple burglary is not per se a crime of violence, but burglary may involve entering a place with the intent to commit a crime of violence or may in fact involve violence in the course of its commission. Thus, whether a person convicted of burglary constitutes a felony involving the violence under the prior violent felony aggravator depends on the facts of the previous crime. Those facts may be established by documentary evidence, including the charging or conviction documents, or by testimony, or by a combination of both. Similarly, in Gore v. State, 706 Southern 2nd, 1328, Florida Supreme Court, 1997, 15 years after the Mann case, which was provided to the court, the defendant complained to the trial court erred when it allowed a prior conviction for armed trespass. which in and of itself has no indication of violence towards a person. They were complaining the court to let that in as a prior violent felony. The Florida Supreme Court said, in upholding the trial court's finding that qualifies as a prior violent felony, the court said, quote, testimony concerning the armed trespass offense established that Gore was found crouching behind the front seat of a woman's car with a loaded gun and a police scanner. The woman who discovered Gore upon returning to her car, but before getting in, summoned a police officer and Gore was apprehended. It's clear that at a minimum, the woman was under a threat of violence. We have held that lack of any actual violence or harm to the intended victim is irrelevant for purposes of this aggravator. So there's a variety of cases which indicate that it is not the name of the charge, it is the facts that go into what happened in that charge. Another case that I briefly mentioned earlier, Anderson v. State, 41 Southern 2nd, 390, Florida Supreme Court, 2003. The state wanted to use a prior violent felony conviction of attempted sexual battery on the defendant's wife's daughter. This was the same, I believe this was the same girl that ended up being a victim of the subsequent murder. The state wanted to use the prior conviction for attempted sexual battery, which inherently in and of itself is not a crime of violence because it's an attempt. The defense claimed you can't use it because he pled to an attempt. The court said, no, you look at the underlying facts, and the underlying facts, as alleged in the evidence presented to the court handling the death penalty trial, was that there was penetration involved in the sexual battery, and it was pled down to an attempt for purposes of plea negotiation.
Which one of the cases is that one?
That is Anderson.
I'd like to distinguish those.
841 Southern 2nd, 390, Florida Supreme Court, 2003. And the Florida Supreme Court upheld the use of that as a prior violent felony because, again, you look to the underlying facts of the crime. In this case, I think the underlying facts of the crime, even in the light most favorable to the defense, shows that a factual scenario involving violence to another person, or at least an unwanted touching to another person, occurred.
Okay, thank you.
Thank you, Your Honor.
Can I be heard in rebuttal?
Hold on. Give me a minute to think. All right, this is the last thing I'm going to hear on this. Go ahead, Mr.
Just
London.
a note on Johnson. It's got a severe negative treatment.
What?
Johnson, the case he cited, has a severe negative treatment. I don't know on what part of the case. I haven't looked, but it really doesn't matter. Because here's the issue. He keeps going back to issues where there is a factual connection. So attempted sexual battery and the penetration, a burglary and the violence. Here we have a situation where he was charged with something that is not even factually true. The fact that someone was picking up somebody, my client, and throwing him down when he is charged with mutiny, and the clear underlying explanation of mutiny is several inmates. That how they can jump over that, Judge? It's like on the sexual battery and the person pled to a simple trespass. I think that that's a distinguishable issue, and I think you can do that with every case. This was a plea to something disconnected with the original plea, factually and otherwise. And there is no factual upholding the issue that you're going to use these facts of this act of violence and put them in a box where my client pled to something that has nothing to do with that and is distinguishable by the issue of taking several inmates, Judge. I mean, you have to just brush that over to be able to say that that would be considered a mutiny, and I think that's incorrect.
Am I correct that none of you has the PSI that was filed?
What, I'm sorry?
Have the PSI that was filed?
I attached it to my motion, Your Honor. I believe it's Exhibit A.
Oh, okay. Let me take a look at all that. I'll get you guys a ruling in the next couple of days. You don't need it right now.
And if I could address just the claim of Johnson has severe negative treatment.
My staff lawyers just told me that it's on a separate issue.
Thank you, Your Honor.
Thanks, yeah. The case was not overturned. It's just a separate issue. All right, let's move on to jury instructions. Everybody have a copy of the very preliminary ones that you sent me.
Yes, Your Honor.
What? All right. I'm hanging on to this exhibit for purpose, I'll give it back to you tomorrow or the day after, but I'll make sure that we don't write on it. Not that I have not been known to do that before. Oh, let me see that too, yeah. Let me have that one, yeah. Let me see this statement this officer made. No, you can just do it as number 2. It didn't have to be identified in any way. All right, 3.1, any objections?
Hold on a second, Judge, I gotta pull this up.
Mr. Buxman, can you forward this? Oh, wait, State's handing you a paper copy. Thank you, Mr. Williams. All right, 3.1, I assume no one has an objection to. 3.2, statement of the charge. This is very preliminary, folks. We'll have to do a charge conference again later. I don't see any issues with that one. .1, introduction to homicide. Any objections at this point to 7.1, defense?
No.
7, all right, justifiable homicide. That seems to be the standard. Excusable homicide.
Justifiable?
Justifiable homicide. I can't hear you, Mr. Linneman. You've got to turn your mic on.
Judge, we would be requesting a heat of passion instruction.
Do you have a proposed instruction?
I do.
Okay, have you given the state a copy?
I got an email.
Okay, thanks. You want this given as part of justifiable homicide?
Well, it's going to have to be after, I guess, the murder charges. I wasn't sure where you place it, Judge.
Yeah, justifiable, I don't believe that even if given, justifiable homicide is not where this is given unless
Okay.
The standard 3 instructions, I believe, put at the end of each individual charge.
this is, so justifiable homicide, do you have any objections to that standard instruction?
No.
Excusable homicide?
No.
Okay. All right. Count 1, first-degree murder of a law enforcement officer. All right, this appears to be the standard instruction. Any objections?
No, I don't think so, Judge, but I just need to check that.
Yeah, this is just preliminary right now. I'm just checking for things that jump out at us. 6.1, introduction to attempted homicide. This is attempted first-degree murder of a law enforcement officer. This appears to the court to be the standard instruction, as
Yeah.
does justifiable attempted homicide and excusable attempted homicide. At the moment, do you have any objections to it?
No.
Okay. Count 2, attempted first-degree murder of a law enforcement officer. I think this one's kind of out of order. No, I'm sorry, it's not. All right. Markeith Carter. This appears to me to be the standard.
Yeah, I agree, Judge, but I get to go back
Okay,
and
so
look.
at this time, I'll just let it be. Count 3, aggravated assault.
Yeah, I think, but I have to look.
Yeah, this appears to be the standard. So count 4, carjacking.
Again, I think that's a standard, Judge, but I'll have to double check. Yeah.
Yeah, I don't see anything jumping out at me. It appears to be the standard. Count 5, possession of firearm by convicted felon. You'd have to take the italics out, obviously.
I will, Your Honor.
Yeah.
That was a note to me that that was still uncertain.
Yeah.
That's fine, Judge.
Okay. All right. Then we have lesser, in 3.4, lesser included crimes. So for count 1, we have first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter. Any others defense is requesting?
Yeah, we're asking for that heat of passion instruction.
No, these are lesser included.
Oh, okay.
Heat of passion isn't that yet. I'm getting to your heat of passion. I just want to go through these first, and then we'll talk about it.
Yeah, I have no objection to this.
Okay. So then we have first-degree murder as to count 1. This takes out the law enforcement portion of it.
Is this the order, Judge, or is it supposed to be right after the?
I haven't checked. No, I normally read all of them, and then I read the lesser includeds, and I do one at a time.
Okay.
Take count 1, all the lessers, count 2, all the lessers.
Okay.
There's so many instructions in this case, if we keep it organized, I think the jury can keep it organized. So I don't see anything on this first-degree murder. It appears to be the standard. But I'll certainly give you time to check that. So then we have second-degree murder of a law enforcement officer.
No objection.
Second-degree murder, taking out the law enforcement officer issue.
Objection.
Okay. Then we have manslaughter.
No objection.
All right, so now we have 3.4 as to count 2, attempted first-degree murder of a law enforcement officer. So right now we have attempted first-degree murder, attempted second-degree murder of a law enforcement officer, attempted second-degree murder, and attempted manslaughter. Are any other lessers requested at this time by the defense?
Not at this time, Judge.
All right, attempted first-degree murder as to count 2, removing the law enforcement officer.
No objection.
Okay. Attempted second-degree murder of a law enforcement officer.
No objection.
Attempted second-degree murder.
No objection.
Attempted manslaughter by act.
No objection.
All right, 3.4 as to count 3, aggravated assault, improper exhibition of a firearm, and assault. Any other lessers requested at this time by the defense?
No.
10.5, improper exhibition of a firearm.
No objection.
Assault.
No objection.
Lesser included attempts as to count 4, carjacking, listed are robbery and grand theft of a motor vehicle. Any other lessers requested at this time by defense?
No.
15.1, robbery.
No objection.
$14.1, grand theft of a motor vehicle.
No objection.
3.3, subsection D, possession of firearm, discharge of a firearm or discharge of a firearm causing great bodily harm or death.
Judge, is that right on the first paragraph?
It reads really strangely, but that is the standard. It sounds as if we're directing them to convict him of everything. It's just weird.
Well, I have an objection to that at this time.
You have what?
An objection at this time.
What is your objection?
This, if you read the jury instruction, it re-emphasizes that you should find the defendant guilty of first-degree murder of a law enforcement officer. We've already had that instruction, and that instruction has like 6 elements.
This is the, I'm not saying that the English in this instruction is the best. I'm saying this is the standard jury instruction for this.
All right, well, I still make an objection.
Says, you know.
I'm just objecting for the record.
Okay. So Any objections to the next paragraph?
Just gets worse.
It just, that's the way the instruction reads. So your objection is to the line, you should find the defendant
Well, I
guilty of-
think you're correct. I mean, it does get worse.
Okay.
So the whole thing.
Are you objecting to the entire instruction or the line that reads, you should find the defendant guilty?
The entire
of-"
instruction.
The entire instruction, okay. Do you have, at this time, a proposed alternative instruction?
I got to first understand what they're trying to say, Judge, because it seems like they're trying to say you should find the defendant guilty of first-degree murder or second-degree murder or second-degree murder, law enforcement, attempted first-degree. It doesn't make sense why they're stacking that.
You have to read, yeah, I mean, I've read this many, many times in many, many trials. I understand what you're telling me, but this is the standard instruction directing them that if they find him guilty and they find beyond a reasonable doubt that he discharged a firearm and caused great bodily harm or death to Debra Clayton, then you should find him guilty of whatever crime it was they found him with discharge of a firearm causing great bodily harm or death. That's what each one of these paragraphs means.
I mean,
and then it goes on to say possession, then there's discharge without great bodily harm, then there's possession.
I mean, I don't understand why it can't be so much more simple.
I wasn't on the committee that wrote this. I don't have an answer for you. This is the standard instruction.
All right, my objection.
So I've noted your objection.
Thank you.
All right. 3.3, aggravation of felony by carrying a firearm. Did we even read attempted manslaughter by act?
It's a lesser of count 2.
No objection.
Attempted first-degree.
Is it, I don't remember it being added.
It's the fourth lesser under count 2, attempted murder of a leader.
It may very well be at this point. I've forgotten what the lessers were on some of this. So as long as it's in there, I have no problem with it. Okay. Personally carried, displayed, used.
Maybe I'll just keep it. I'll give it to you.
Any objections to this one?
Thank you. No objection. Yeah, that's what you're saying.
3.6, insanity.
No objection.
Okay, the italics portion of this, you're going to take out the italics.
Take it out.
Yeah, I'm not crazy about italics or bold. In,
No, I mean the language itself. I looked at it as italics because I wasn't sure if that was going to be included.
Let's read that. It says, a defendant who believed that what he was doing was morally right is not insane if the defendant knew that what he was doing violated societal standards or was against the law. Unrestrained passion or ungovernable temper is not insanity, even though the normal judgment of the person is overcome by passion or temper. Since you're requesting a heat of passion instruction, that would mean that I would need to read this.
Okay.
All right, so leave it in.
Yeah. And what about the last one, last paragraph?
Which one?
About that he may not go to be released from
Oh,
custody.
I hadn't gotten to that page yet. If your verdict is the defendant is not guilty, he will be released from custody. Yeah, we're going to take out the words "or released" out of this because he's not being released.
Take out the entire last paragraph.
No, I mean, we can if you want to. If your verdict, it's up to the state. What do you want to do with it? And this paragraph, for the record, is if your verdict is that the defendant is not guilty by reason of insanity, that does not necessarily mean he will be released from custody. I must conduct further proceedings to determine if the defendant should be committed to a mental hospital or given other outpatient treatment or released.
In light of what we have told the jury, that he's already convicted and sentenced to life, I don't see the need for that paragraph.
Fence? Okay.
I just leave it open because I have to talk to my clients more about
All
it.
right, so we're going to leave it in italics. I'm marking it as coming out unless I hear differently from defense. And then I'll rule at that time. So it doesn't appear to apply in this case at all, and we have told the jury repeatedly that he's been sentenced to life without parole. All right, 3.6H, justifiable use of force by law enforcement officer. Any objections?
I do, Judge, but I need to research it.
I'm sorry?
I just need to research this issue. I mean, if it's the standard and it applies factually, obviously I won't object, but I just need to take a look at it closer.
Okay. Well, like I
leave it in
said,
for
this is
now,
all of this is preliminary. All right, let me make sure you guys change this. You must find the defendant. Okay.
You know what, Judge? I will, I agree to 3.6H.
You're not objecting to it?
I'm not objection.
Okay. 3.7, reasonable doubt.
No objection.
.8, evidence of other crimes, wrongs, or acts, Williams rule.
No objection.
3.9, weighing the evidence.
No.
The only one I removed was, I believe, 10 dealing with reputation. I think there is going to be
Which one did you remove?
reputation.
Okay.
All right, 1 through 4, 5, all those are normal. 6, has the witness been offered or received any money, preferred treatment, or benefit in order to get the witness to testify? Is there any evidence of this at this stage?
We're going to have a lot of experts being paid.
Oh, I forgot about those. Okay, we'll leave that in. Pressure or threat been used against the witness?
Well, yeah, I mean, I'm alleging, and I'm going to call Mr. Sturby in my...
You're going to call who?
Sturby, remember the guy?
Oh, Sturby?
Yeah, I'm going to call him. And
Okay.
there's some
All right, so
kinda
we'll leave that one
fishy
in.
stuff.
And then inconsistent statements, we've had that come up, and we've had a witness who's been convicted of a felony. All right, any others? 10 doesn't apply, so.
No.
All right, the testimony of a witness who helped the defendant commit a crime or has been promised immunity, is anyone anticipating said testimony to come out?
The only reason I left that in is because if Mr. Stribby, Brian Stribby, testifies at the first trial, there was an allegation made by the defense that he received some kind of deal for his testimony. There's no factual basis to support that, but that information was brought out.
All right, so I'll leave that one in for right now. We'll see what Mr. Stribby says on the stand.
And so you're not confused, Your Honor, I put 3.9 instructions in there. One has a paragraph up and a testifying, one does not.
Okay, thanks. All right. 3.9, defendant not testifying. If that one is read, do you want both paragraphs read, Mr. Lenneman?
That's fine.
Okay. (3.9B) defendant statements. There haven't been any so far. We'll leave it here, just in case. 3.10, rules for deliberation.
That's the standard, right?
You took out the one about jurors asking questions, right?
I did, Your Honor.
Okay. Cautionary instruction, 3.11 is the standard. Verdict, 3.12.
That's fine.
3.12A, single defendant, multiple counts. That one's standard. 3.13, submitting case to the jury.
I wasn't sure how you handle the cell phone issue.
Yeah, I'm going to take it out because the deputies have their cell phones and they're not here. Any objections, Mr. Lenneman?
No.
Okay. Okay, that statement, these exhibits will be sent into the jury room, they will not. The guns aren't going back, so that needs to be changed. Some exhibits will be sent into the jury room.
And you're going to, a stupid question, but you're going to specially explain to them the process if they need to see a video.
Yeah, that's what I'm going to say right now. So
Okay.
some exhibits will be sent into the jury room with you when you begin to deliberate. If you need to see other exhibits or a video, and I usually verbally tell them we don't send the firearms back unless they ask for them. Other exhibits or a video played. Please request that in writing. In writing. You know what, change that to, or a video played, they will be provided upon request. I want to make it clear to them that we will give them what they need, yeah. All right, let's take a quick look at the verdicts. Count one. Any objections at this time, Mr. Lenneman?
No.
Count two. Any objections?
No.
Count three. Any objections? Is he raising insanity as to the carjacking, the attempted murder? I thought he was raising insanity just as to Lieutenant Clayton. Or is he raising it as to everything?
No. Judge, I just want to raise it to the first degree murder.
I'm sorry?
Just the first degree murder.
Yeah, I don't think insanity is being raised as to count 2, 3, or 4. And count 5 would not be subject to an insanity defense.
Okay. Yeah. He wants to talk with me about it, Judge, so we just leave it open.
All right, so we're tentatively crossing it out, but don't take it out yet. All right?
Okay.
And then count 5 is the possession of firearm by a convicted felon. Are you raising insanity as to that one? Or is that the same answer? You want to talk to him a little bit?
Yeah, we need to talk about all this.
All right, I'll just kind of lightly trust him. Then we have the special findings.
Okay.
Count 1.
No objection.
Count 2. They seem to be the standards. Do you have any objections to them at this time?
No.
All right, let's take a look at the requested heat of passion instructions. Is this the standard or is this one you came up with? Mr. Lenneman?
What, Judge?
The heat of passion instruction here, let me take this off.
Correct.
The heat of passion instruction you gave me, is that the standard heat of passion?
No.
The one that you drafted?
So.
Okay.
Ms. Miller drafted it.
Right. So I'll say one the defense drafted.
Yes. And then I also have one that's tentative. depending on circumstances.
I'm sorry, what?
I have one more that's tentative.
Okay, let's start with heat of passion. State, have you had a chance to review this? Did you bring a copy?
No, I
for
haven't
State?
been able to email it to him yet, Judge. Can we just put those on hold until we talk again?
You can take a look at it right now if you'd like. While I read this justifiable use of deadly force.
I'm ready to just send it to you in email.
Thank you. The language in the proposed heat of passion does appear to be standard in the jury instructions for each of the counts.
Okay.
Not
And then
saying
here's the
agree
just-
that we think it's appropriate, but they are the same.
You guys read that one? Have you, the justifiable use of force one, all right. The heat of passion instruction, I assume this would be an alternative defense? I think he gets it. I don't know that this is the correct wording. State, you want to be heard on this? It would be an alternative defense.
Wait, hold on, Your Honor. At this point, Your Honor, I don't know if we have evidence in the record to support giving the instruction. I think we need to table this, let us do a little bit of research and wait until some of the facts are brought out further.
Yeah, I should clarify. I'm not really ruling it's in. I'm saying if there's evidence in the record, even a scintilla, when we're at the end of the case that supports this, then he would get the instruction as an alternative defense.
Yes, Your Honor.
That's a much better ruling than what I just said, but it's been a long day.
I'm sorry, Your Honor.
So, no, that was on me. So we'll table this for the next jury instruction, and I need to check the language. It does look like the standard, but I haven't checked the language, so I'll check that. And then we have the justifiable use of force by Mr. Loyd requested instruction.
And my response will be the same.
Okay. Yeah, that is just the standard instruction, but with Mr. Loyd, the only question I have about that one is the stand your ground portion of that. Mr. Loyd is a convicted felon in possession of a firearm. He is legally not entitled to a stand your ground instruction, and I would not read that portion of it unless you have some case law that it's changed.
No, I think, we talked to Ms. Miller, my research
Can't hear you. What?
Let me talk to Ms. Miller, but my preliminary research agrees with the court.
Yeah.
The court.
I don't think he's entitled to that portion of it. So, Dave, if I could, you're going to email them this, right?
I just did.
You have them, if I could have my written one back. Are you done with it when you're done?
I am, Your Honor.
Okay, thanks. All right, anything else on, let me try that again. Anything else on jury instructions? Or anything else that we need to discuss?
Not from the state at this time. No, never mind. Apparently, Mr. Williams has something.
Of course he does. Mr. Williams, what can I do for you? Go ahead.
The way that was said, I just don't know. I spoke to Mr. Linneman late morning about some of the witnesses. He's informed us of the witnesses, and I think we discussed it at a bench conference that we're trying to help him coordinate some of the witnesses.
Okay.
It's the state's position that several of those witnesses do not have admissible evidence. And I believe Mr. Linneman is in agreement that we can resolve that, if possible, today to prevent those people from coming in, getting on the stand, us raising an objection, and then having to break the rule.
Okay. Go ahead.
So it's the state's understanding that the defense intends to call crime scene investigator Ed Vanderberg, specifically for the purpose of admitting the letters that were found at the Lescott Lane address that Mr. Loyd had written. It's the state's position that they are self-serving hearsay that does not meet an exception and that they should be excluded. That is the only purpose for Mr. Vanderberg's testimony, that his testimony should not be permitted.
What's in the letters?
His version of the events of the Dixon murder, for the most part. And I'm happy to listen, obviously, to defense counsel if they believe that there's specific portions of it that are relevant or meet an exception. But generally, it's, I believe, 7 or 8 pages of his explanation for what happened the night of December 13th.
Okay. Mr. Linneman, what are you admitting these letters for?
We call it his manifesto, Judge. It was written while he was in the building where he ended up. So,
Do you have your mic on?
Better?
Yes, much better.
Okay.
Go ahead.
We call it a manifesto that he prepared while he was, just before he surrendered on this issue. So he had been on the run since Lieutenant Clayton's murder. And it is a narrative of material that collectively and individually go to his state of mind at the time of leading up to his arrest, but including things that had occurred between Dixon and leading up to the Clayton murder.
And
So-
why would he not be required to take the stand and testify to that if he wants it in evidence? What would be the exception that would allow written statements by a defendant into evidence?
Okay, so I agree with the court. He will testify, but I need a predicate to establish, because he's the one, unless they agree by stipulation, he's the one, Vandenberg is the one who collected it at the house.
So all you're putting this gentleman on for is to say that he collected these letters at the house?
It's not a letter, it's one letter.
Oh, I'm sorry, okay.
Yeah.
But he collected, I remember some papers in the photograph.
Yeah, and I crossed him on it, but, I couldn't introduce any of that or ask him about that.
And then later on, you're going to try and lay a predicate through someone else to get it in?
Yep.
State?
Judge, we would stipulate that those letters were found at the Lescott Lane address by
That's fine.
Mr. Vandenberg.
All right, so can that witness now be released and excused?
Yes.
All right, you may release Mr. Vanderberg?
Vanderberg, yes, Your Honor.
All right. Who's next?
Detective Michael Moreshi and Detective...
Can I ask one more question?
Yes, sir.
We have a and I don't know if the state agrees on this, we have a handwriting expert who looked at those way back when we were dealing with the Dixon case and compared those to Mr. Loyd's handwriting, and he would testify that they're one and the same. I don't know if it's also a predicate before I bring it in through other parties.
Judge, state would stipulate that as to the letters found, that Mr. Loyd authored them.
Okay.
Okay, perfect.
And we're talking about the ones found inside the Lescott Lane house
Correct.
that can be seen laying on top of the makeshift bed. Is
Right.
that correct?
But they're going to have to bring it because I don't know if they brought it over already.
We'll make sure it's here.
Okay.
Okay?
All right, so the handwriting expert does not need to testify.
I will let it release him.
All right.
Anything else?
Not as to that witness. I was moving on to the second witnesses.
Oh, yeah, go ahead.
Detective Michael Mareschi and Detective Michael Fields. My understanding is that they would be called to admit at least one call or transcripts of a call intercepted between Mr. Loyd and other witnesses where Mr. Loyd references potential of surrendering. Our objection is the same, that it's hearsay, it's inadmissible, and that therefore these witnesses do not need to be called.
Mr. Lenneman?
Yeah, it's non-hearsay, Judge. There is material within those calls that go to his state of mind. There are actually 3 separate calls. I have a transcript I can email the court, which is 17 to 19 pages if the court wants to view that in regards to that issue. But I plan on calling them because, as you remember, there was a whole issue about wiretaps. And the only people that we got wiretaps through was the state attorney, and it was done kind of in a way that they only let us know about 2 people who were involved in that particular.
What does that have to do with the admissibility of these wiretaps? Because it's the content that, it's not the wiretaps themselves right now.
Right,
the
right.
issue, it's the content.
Right, it goes to his state of mind. It's not hearsay. It's not being offered for the truth in this particular
What is it being
portion.
offered for?
I'm sorry?
What is it being offered
His state of mind.
What state of mind?
His state of mind at the time of the wiretaps, which is important, as is his state of mind at the time that he's giving up and surrendering, because he's still continuation of his mental illness. And there's evidence within those calls that I support that. So it's non-hearsay.
What specifically? I mean, you can send me 17 pages, but if all you're trying to admit is 5 statements that go to his state of mind, then just tell me what they are and then send me the 17.
I don't have that information right now on me, but
Okay.
And if they would agree to stipulate to those coming in, subject to their objections, so we don't have to call Mareschi and Field, then we can call off Mareschi and Field.
Your Honor, the issue is Mr. Mareschi lives in North Carolina.
Doesn't what?
Lives in North Carolina.
Right.
And is retired.
Okay.
Detective Fields can come in, but tomorrow is when this is going to happen, and we don't know what the statements are. The only statement that I have ever seen that has become relevant to anything, and that's relevance according to the defense, is Mr. Loyd's statements about turning himself in. And they're just not relevant. And state of mind exception is 90.803 sub 3. His state of mind at the time of apprehension is not a material fact in this case. So I'm happy for Your Honor to review the calls, but we are unaware of any exception that they would meet.
Well, the turning himself in is not relevant to any material element of any of these crimes. That's just not in the guilt phase.
Correct.
We're just talking about guilt phase.
I agree.
So turning himself in, none of that's coming in, all right, right now. I'm just talking about guilt
Right,
phase.
but here's the situation that actually is relevant, and the state made it relevant, because they put these Facebook pages in that say, oh, Mr. Loyd, what are they talking about? being harmed to a police officer, and he's venting about some of those things. They put that issue in play. And so this is important to rebut that issue.
Turning yourself in and Facebook statements about harming police officers are two completely different things. I'm not seeing the connection. I don't see what turning yourself in has to do with Facebook statements about wanting, I mean, let me be blunt, about wanting to kill police officers.
So imagine that Mr. Loyd gets up there, and he explains in detail what was going on when he made those 3 Facebook page explanations. And the jury says, oh, you know, that's reasonable, I guess, or maybe I need to know something else, that he's going to turn himself in. Oh, yeah, then, you know.
That's not relevant to the guilt phase. I'm not letting in statements about turning himself in.
All right, let me look through and see if there's anything else.
And again, these rulings are all guilt phase, all right? Okay, so next.
So just so I'm clear on this, we had agreed, Mr. Williams and myself had agreed for Mareshi to appear by Zoom and not have to travel down here if he was going to testify. And that was that's still my intent, subject to the court excluding the whole phone call. So I just want to make sure.
We still agree on the Zoom issue. The issue is whether or not he can testify at all about the content he's going to be asked about. If he needs to appear because the court rules that he has admissible evidence, then we will make him available via Zoom.
Yeah, and all I'm saying right now is I don't need to hear from anybody about turning himself in. If there's some other statement in there that you believe is relevant to the guilt phase, happy to look at that. Okay. Next.
Detective Brian Savelli, we believe will be called for the purpose of attempting to admit a press release from the Orange County Sheriff's Office regarding the Dixon murder, which we do not believe is relevant to any material fact. And if that is the only reason for him being called, we would ask that he not be called as a witness.
Why are we calling Savelli?
That's incorrect, Judge. Because he testified, we called him at the last trial, and we didn't try to introduce a press release, nor are we going to try to introduce the press release now.
So you're calling Savelli for another purpose?
Yeah, Savelli is being called for the issue of that he had contact with my client's niece, and there was that whole thing about the news, as we pointed out earlier.
That goes back to the turning himself in. What's the relevance of that?
No, not turning himself in, his state of mind, that he decompensates when he finds out that this issue happened where the priest had...
Is this before or after Lieutenant Clayton is shot?
This is before.
Okay. All right, you're right. He did testify to all that.
Right. And so all we're putting it in for is to show that he decompensated, and that was one of the issues where this whole police are trying to kill me involved again.
You do realize,
Yes.
and I know you realize this, Mr. Lenneman, that Detective Savelli's testimony may open the door for rebuttal by the state on facts surrounding the Dixon homicide.
I know that was your ruling previous.
Okay.
Well, Judge, just so everyone's aware, I'm assuming defense is aware that Detective Savelli would testify that during those conversations, he begged and pleaded with Mr. Loyd's family to have him turn himself in peacefully. So that's going to become relevant. We don't believe it's relevant, but I understand the court's ruling, and if they want to call him, then...
Well, I'm not expecting him to get up there and the defense to start eliciting testimony about Mr. Loyd turning himself in, because I've already said that's not relevant. He's telling me he's going to put him on there solely for the issue of the press, Mr. Loyd's belief that the press was and the police were pushing, I can't remember if it's both of them or one of them, were pushing a false narrative, and that is tied into his insanity defense, is
Right.
my understanding of this.
And how could Detective Savelli possibly provide that testimony that's not
He
hearsay?
cannot tie it to the insanity defense, but he can provide, I mean, I guess I have to hear the testimony. He's not a clear-cut no to me at this point. He did testify in the first trial, although, quite frankly, I don't remember what he said.
The only request we would make is on that witness, we proffer his testimony.
That's fine, I don't have a problem with that.
Yes, Judge.
Just proffer him quickly beforehand? Okay. What else? Oh, you're the one making the objections. Go ahead, what else?
Lieutenant Douglas Gerke, actually Captain Gerke, was with the Orlando Police Department. It's our understanding that he's going to be called to say that he played a role in bringing Lieutenant Clayton's handcuffs to the apprehension scene and handing them to officers so that they could put them on Mr. Loyd.
Part of our theory, Judge, is OPD has a bias process that's already been in place since the shooting of Lieutenant Clayton, and this was one more piece of the puzzle that they decided from higher up than Gorky, because he says that in his depo, that they were going to use these handcuffs and take the old handcuffs off and put the old handcuffs in. So it's clearly showing bias of the OPD.
Bias by an agency or bias by a particular officer that is testifying?
Well, he won't say it's Chief Mina, but that's who I believe it is.
So bias by an officer that is not testifying?
Biased by the chief of police who oversees the entire police department and is responsible for the men under him.
I'll grant you that it shows anger at the death of Lieutenant Clayton. I'm not clear why it shows bias.
Well, I think in the original approach on this issue, our attempt has always been to remove the curtain from what was really going on. That includes the beating of Mr. Loyd by 4 OPD officers. That includes the 2 detectives, including Cadiz, sitting in front of him while he bleeds profusely for an hour and not getting him any medical attention. The handcuffs are just another piece. So it was our intent from the very beginning to put all that stuff off, and I know the courts have ruled against us on.
It's not relevant to guilt phase. These are all things that are not relevant to the essential issues or the essential elements of the crimes with which he's been charged. I don't see that this officer's testimony, he's not an investigating officer, right? He has not been called as a witness.
Correct.
Bias goes to a specific witness on the stand, not to people who haven't testified, aren't being called. So if that's all he's testifying to, I'm afraid the state is correct that testimony would not be allowed.
Over our objection.
Over your objections, yes. Next.
That's all.
Right, anything else we need to talk about before tomorrow morning?
Well, my client has asked me to read some things into the record.
He wants you to read some things into the record?
Yes.
Sure, go ahead.
Okay. You want me to read that? All right. The only thing we want to put forth is that Markeith came to the house, flashed the light on Ron's window, and knocked on the door. Ron answered and called Sade to the door. Sade and Markeith walked out to the cars. Dominic gets dropped off and goes in the house. Sade goes in the house a while after Dominique, and 20 or so minutes from the time Markeith arrived and she came out, Sade went up to the stairs and came back out eventually. Ron comes out and and the incident, it happens. We are not going into details of the incident. We're only putting forth to the state of mind of the defendant as to the report was told to the news and public that Markeith just came over to Sade's house, banged down the door and gunned her down, which plays into the state of mind of Markeith, because what the news reported
was not true of what happened, and detectives had the statements of Ron and other family members, but report a false story to the news. Okay.
Is that it?
Yes.
Okay, thank you. All right, we're in recess until 9:30 tomorrow morning, where we're going to start with the defense's case. I'll get you all a ruling on the aggravator in the next couple of days. All right, court's in recess. Let me talk
Judge,
to
one
you.
more thing he wanted me to say, that
Sure.
goes to his state of mind.
Okay, thank you, Mr. Lenneman. All right, folks, let me see the attorneys for a minute.